Good morning, Judge. Chad Grunander, Ryan McBride, Chris Ballard, Lauren Hunt, and Jeff Gray.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated at the table.
Good morning.
Good morning, Your Honor. Jeff Hunt and Mike Judd on behalf of the news media.
Good morning. And the court also recognizes Mr. Robinson. Good morning to you. All right, before we address the motions before the court will take up a couple of preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. I will note that for today's hearing, we're going to turn off the microphones at the jury box and at counsel table. And so I ask, in order to avoid picking up inadvertent conversations or communications, and as you speak, if you wouldn't mind just coming to the lectern, and that will be the microphone that will be live for this hearing. Next, turning to the camera operator and still photographer. So would the two individuals responsible for video and still photography please come forward and state their names for the record.
Your Honor, Trent Nelson with the Salt Lake Tribune is still photographer.
Good morning.
Your Honor, Jeremy Dubas, KUTV 2 News videographer.
Good morning. All right. The court's purpose is to ensure the clarity regarding the expectations governing today's proceedings. And have you reviewed the court's standing decorum order dated February 24th, 2026?
Yes, Your Honor.
Yes,
All right.
Your Honor.
And do you understand the requirements set forth in the order as they apply to your activities today?
Yes, Your Honor.
All right. Do you require any additional time to review the order or to adjust equipment to ensure compliance?
No.
And do you anticipate any difficulty complying with the order or the court's instruction?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Dubas, I appreciate your cooperation today. Thank you.
Thank you.
Turning next to discovery for this day, could you provide a brief status update regarding discovery? Mr. McBride.
Well, we had provided a
Go ahead.
As of May 12th, we had provided 100% of the material in our possession. We received additional discovery from the State Bureau of Investigation over the last week, and that material will be transferred to the defense very soon, probably this afternoon.
All right. Thank you, Mr. McBride. Turning to defense, do you request the benefit of the record?
Thank you, Your Honor. Since our last status update on May the 4th, we have received a total of 2,462 more files. Over 2,300 of those were residential surveillance camera videos. Many of those we did have previously. The remaining files were ATF and FBI without the DNA data, reports and files, and then some 1102 statements, some jail records, some other law enforcement reports. I appreciate that the state has given us 100% of what they have. We really don't have a feel for how much they still have not gotten. I don't know if they know. It seems like it's just constantly coming in, but we do appreciate how fast they're turning it over. But when you say we have 100%, I think what they're saying is they have 100% of what they've received has been sent to us, but there's still maybe quite a bit out there that we just don't know how much it is.
All right.
Thank
you,
you,
Ms.
Your Honor.
Nestor. All right, well, let's turn to defense's motion for an order to show cause for alleged contempt of court and for an order compelling discovery related to the alleged contempt. And just for management purposes, each side will have 30 minutes to present argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Afterward, we'll take a 10-minute recess. And because this is defendant's motion, defense will proceed first. And again, as a reminder, this argument is in regards to whether the court grants an evidentiary hearing to hear additional evidence. And that's the decision that's before the court. With that, turning to Mr. Novak.
Thank you, Your Honor, and good morning.
Good morning.
I think as the court stated, there really are two issues before the court today. One is whether under Utah Code Section 78B-6-301 et sec, this court has an obligation to issue an order to show cause and set an evidentiary hearing. And the second question is whether in preparation for that, the court makes a finding under Rule 16 of good cause to compel the state to comply with our informal discovery request. And what I would like to say is that it seems beyond debate, based on the evidence before this court already, that the court does have an obligation to set an OSC evidentiary hearing. It's important also to note that the statute 78-6-309 actually says that the court investigates the alleged contempt and may call witnesses. So I'm actually, if I may, gonna address the two issues in reverse order, which is the discovery issue and then the hearing issue. The communications, the events, the conversations, the state of mind of the various members of the prosecution team with respect to the decision for Mr. Ballard to go on what I will call a media tour is central to not only the core question of whether there's been a violation of the court's order, but frankly, the egregiousness of that violation. While we pointed out in our
just so you guys know what this hearing is about, if you're just getting in here, this hearing is about obviously the last hearing, the judge refused to block all cameras from all, blanket. They wanted a blanket block preventing cameras from being in the courtroom for every single hearing moving forward. The judge said, no, that's unconstitutional. We're not going to do it. And instead he said, it will be on a case-by-case basis. If you want cameras blocked, then you have to file a motion per each hearing that you want something blocked. So immediately at the end of that motion, they filed on the record a motion to bar cameras once again from the evidentiary hearing, which, is set to come up. They've just rescheduled it, I think, for another couple months or whatever. So they're hearing that motion now, whether there will be cameras allowed in the courtroom for the evidentiary hearing. And also there's a motion of contempt on the prosecution for speaking to the media, which prejudices Tyler Robinson. So that's what this hearing is about, just so you guys know.
Our papers, and the state did not take issue with this in theirs, that because the court's orders, the court's pretrial orders, are injunctions, we don't actually have to prove there's been an intent to violate the order. The fact that what I'm going to call an alleged contemner knows of the order and has failed to comply with it, those two elements are all that is necessary. But the question of the seriousness of the violation, the sanctions that should be imposed in light of the violation, do get at intent. So intent is not irrelevant, but it's not an element of what I might call the alleged offense of contempt of this court's orders and violation of Rule 3.6 and 3.8. So we think that this court can't really fulfill its statutory duty to investigate without the parties, well, without the court and Mr. Robinson knowing what communications the Utah County Attorney's Office had with various media outlets, what the nature of those conversations were, what the nature of the internal conversations were concerning whether Mr. Ballard should go on Fox and Friends and have a nationally and internationally televised interview, whether the Utah County Attorney's Office should issue emails to media entities. And the Supreme Court's decision, which has been cited to this court in the briefings in the matter of Levitt, clearly showed this court that the alleged contemner's awareness of problems with their conduct is central to the inquiry. So one of the first things that the Supreme Court said in its opinion was that after Mr. Levitt had his press conference and he went back to his office, people in his office said, wow, that's a problem. And so that internal communication is central to this court's assessment of what we would call the seriousness of the violation.
Well, Mr. Novak, let me stop you right there. Is the violation what happened allegedly? Because I haven't watched the interview or what's been purported. Are you saying the violation for the potential sanction is what happened on the news or what happened behind closed doors?
The violation is what happened. The violation is extrajudicial statements that have a substantial risk of impacting the proceedings. Okay, and the two specific violations are Mr. Ballard's statements on behalf of the Utah County Attorney's Office. So the question really is, and I'm not suggesting that this is the case, but the question is, did Mr. Ballard go off on his own and do this all by himself, or was there a management decision to go do this? Okay, but the conduct that is a violation of this court's orders is to make extrajudicial statements about forensic evidence, not only what the forensic evidence is and the testimony will be, but if the court looks closely at especially Ms. Visser's declaration filed in support of the motion, Mr. Ballard commented on what future versions of ATF and FBI reports will say after future testing is done, as if he somehow had a crystal ball as to what the evidence ultimately will be. And the second violation is statements that clearly are expressions of opinion as to Mr. Robinson.
That's a defense lawyer, by the way.
And these are two of the examples highlighted in the comments to Rule 3.6. I mean, this is textbook. Don't go out and say these things extrajudicially. And if the court looks at the exhibits to our motion, what the court sees is the Utah County Attorney's Office was very cognizant of the fact that Rule 3.6, Rule 3.8, and this court's orders prohibit those kinds of statements because they sent letters to what I will refer to as their law enforcement partners, basically saying, don't go out and make extrajudicial statements. So I'm going to get back to the court's question. The court's question is, where is the violation? The violation is the extrajudicial statements. What I'm saying about the need for this court and for Mr. Robinson in order to meaningfully participate in the OSC hearing to understand how it is that Mr. Ballard came to be going on this media tour, because that gets to the seriousness of the misconduct and the types of sanctions that are appropriate. So I'm not saying that a conversation between Mr. Ballard and, let's just say hypothetically, Mr. Gray, that's the question, is where did these conversations start and where did they end that led Mr. Ballard to send emails to media entities and agree to sit in a studio or at least online and talk to Fox News? that's not, the conversations are not the violation. The conversations guide this court to the state of mind with respect to the violations and the sanctions that are appropriate for violation of the order. The other question, which is related, is what is the harm to Mr. Robinson, which is something that the court is going to have to grapple with now. And as the Baum litigation demonstrates, and we attach what we think are the relevant orders from the Baum litigation, the remedies that are necessary to attempt to return Mr. Robinson to the place he should be in terms of the presumption of innocence, in terms of having a jury that hasn't been impacted by these.
That's so true.
violations.
That's the foundation of our country.
The discovery request is narrowly tailored in time. It's from March 26th until whenever the production that we requested was made, March 26th of this year. We were not
Oh,
asking
thank
the
you.
state for every single communication they've ever had with a media outlet since September. We were asking for communications since March 26th because it was clear that the moment we filed our motion to continue the preliminary hearing, the state decided that the way they would shape the media conversation about Mr. Robinson's case was to issue emails to the media and have live interviews.
So counsel, you mentioned 78B-6-309, and it states the court shall proceed to investigate the charge and hear any answer which the person arrested may make. So would you agree it's the court's duty to investigate and decide what is necessary for the court to make that decision?
The court is entrusted with deciding whether or not there's good cause to require discovery. And I'm saying that in order for the court to conduct the investigation, which is required by the Utah Code, the
Right.
court needs the materials that we were requesting. And good cause means materiality. So clearly, the communications between the Utah County Attorney's Office and the media and the internal communications, not about case strategy, not about witnesses, not about evidence, but about communications with the media, which led to what we think clearly is a violation of this court, two violations of this court's orders, is germane and necessary to the court's investigation. However, that doesn't mean that this court conducts an in-camera proceeding that Mr. Robinson is excluded from. We are the moving party. We have very serious constitutional rights, which we need to make sure that this court understands the nuances of in terms of the impact of the conduct and the seriousness of the conduct. So this is not a situation where the court, in my view, should receive the materials we requested in camera, not share them with Mr. Robinson, and not permit Mr. Robinson to participate in the OSC. I don't know if that was what the court was suggesting. What I'm suggesting is that the court should compel the state to give us the materials which we requested. If there is any question as to whether some of it may be privileged, the court can review it in camera, which is what we said in our papers. But that doesn't mean that the court conducts its own ex parte in-camera proceeding without us participating.
Sure. No, I'm not suggesting that. I'm
Then
simply saying.
I read something into the court's question that was unnecessary.
Right. What I'm saying is, would you agree as part of this investigation in a hearing that the court determines what is necessary for the court to make that decision in regards to your request for discovery?
Yes, I think the court has to exercise discretion, but it's our position that the appropriate exercise of discretion is to compel the disclosure, for the court to review those materials, for Mr. Robinson to review those materials. If the court is concerned that internal deliberations produced in discovery need to be subject to some sort of protective order before there's an evidentiary hearing, that's fine. We've always been fine with protective orders. I think that we've been the party in this case has always said less premature public disclosure of sensitive materials is best. Okay. And that, if I may, actually leads me to this, what I'm going to call a diversion about this ATF report. Okay. So our motion to continue did not mischaracterize the ATF report. What the state wanted to do is expand upon the inconclusive nature of the ATF report. And instead of doing that in this courtroom, they went on a media tour to do it because the media misinterpreted what we said in our motion to continue. Our motion to continue is accurate with respect to the ATF report. And I would also point out that it was Mr. Ballard, and this is an email from Mr. Ballard to us attached to Ms. Visser's declaration, which says that the state thinks that that ATF report should stay under seal because to publicly file it would be a violation of 3.6. It would be an end run, to quote Mr. Ballard, around Rule 3.6, because it would be filing in the public record a forensic report. Okay, so but at some point in time, for some reason, the state decided that report should become public and everything should become public. And the court granted that motion. And so that ATF report became a public document. And so in a court filing, we accurately characterized what's in that ATF report in support of our motion to continue. The court is well aware that there has been a dispute about the FBI's desire to do destructive testing without documenting that testing or allowing one of our ballistic experts to observe the testing. And so that's sort of like sitting there. But that's why that ATF report was initially lodged with the court in camera until the state decided, or I should say privately, to use the appropriate Utah term, until the state decided that it wanted it to become a public record. Okay, so the other thing that I want to say, and I'm going to save a few minutes, is that the state tries to take refuge in the notion that because we've made public statements, albeit in court filings, about something that the state thinks has been mischaracterized, that they get to go out and talk to the media to correct things. And that is not what Rule 3.6 permits. And that is not what the Supreme Court in the Levitt situation and in the Baum litigation sanctions. If Mr. Ballard and his colleagues thought that we mischaracterized the ATF report, which we did not, but if that's what they really believed in good faith, they could have done at least three things. One, they could have filed something with this court, a judicial communication, which said, we think that Mr. Novak and his colleagues have mischaracterized this ATF report. And our view of the correct characterization of the ATF report is as follows. Number two, they could have reached out to us and said, we think that you have either inadvertently or intentionally misconstrued or mischaracterized this ATF report, and we would like the parties to file something, or we would like you to consider amending your filing. They could have done that. Neither of those things happened. Instead, what they did was they drafted an email and they sent it to media entities like TMZ, and they scheduled an interview for Mr. Ballard with Fox and Friends, where he characterized it extrajudicially. And that's exactly what 3.6 prohibits. The fact that they didn't agree with the way we characterize.
Holy crap. So what he's telling you right now is the prosecution is colluding with the media, with TMZ, with Fox News, with Andrew Colbert and all them. He's colluding by telling them, giving them talking points, saying, hey, this is not correct. That, this ATF report, we need to make sure it's being read in this light, not the light that the media or that the Daily Wire put it out or whatever. So what that's why he's seeking contempt, is because they're colluding with the state. I mean, he's seeking contempt because the state is colluding with the media.
Evidence to this court is not an excuse for violating 3.6 and not an excuse for violating this court's orders. And this court will remember, I'm going to conclude now, that when the state challenged this court's pretrial and trial order and said that it was a prior restraint and that it was vague, I stood here and I defended the court's order because it wasn't a prior restraint on anybody other than counsel and their investigators. It's not a prior restraint on witnesses. It's a prior restraint on counsel. So there is no doubt that they understood that they can't be making extrajudicial statements about Mr. Robinson's guilt or innocence or about the forensic evidence. Those are two comments that are right there in Rule 3.6. Mr. Robinson has a right to a presumption of innocence until the matter is submitted to the jury. This court's done jury selection, I'm sure, in many different ways. And when the jury is in the box being selected, he has a presumption of innocence. Every day he has a presumption of innocence until the matter is submitted to the jury for deliberations. And that is something that Mr. Ballard knows, and he and his colleagues violated that right. And this court, in my view, needs to get to the bottom of why did this happen? Who was involved? What was the state of mind? Why didn't they do what the law requires, which is file something if they thought a correction of the record is necessary? The ATF report is in the public docket. It's there. It doesn't matter what Fox, CNN, MSNBC, TMZ, it doesn't matter what they think of the report or what they think of our pleading. The only person who judges our pleading is Your Honor, not the media.
And
I've saved 3 minutes.
all right, just a quick question for you.
Of course.
Assuming the court grants the request for an evidentiary hearing, how much time do you anticipate needing to present what you would like to present? Assuming, and if there's a difference, assuming you do get discovery that you're requesting, or if you don't get discovery, I just want to take that in consideration as well.
Thank you, Your Honor. I appreciate the question. And unfortunately, the discovery will tell us how many members of the Utah County Attorney's Office were involved in this decision. If it was Mr. Ballard all by himself, then there may only be one witness. I think the media evidence speaks for itself. We've lodged some of it as exhibits and some of it through hyperlinks, all in Ms. Visser's declaration and the attachments to it. If the discovery shows that there was a team meeting and there were a bunch of emails about it, then it may be that there has to be, that from our view, multiple people need to be examined under oath. So I'm not trying to dodge the court's question. I think that it's definitely no greater than a single day. I mean, I don't think this is a multi-day hearing. But I think the question is, how many people were involved in the decision for Mr. Ballard to go on national television and send emails to the media? And I can't answer that question. And so I can only give the court this general idea that I think it's a serious hearing that should take no more than 1 day.
And if the court doesn't grant the request for discovery and it's that sole witness, and I'm not holding you to that, obviously, how much time would you anticipate that would take?
So then, if I may, the examination, and I can only start with Mr. Ballard because he's the one who made all the public statements. The first questions would be, who did you discuss this with and when? And then we're going to get into hearsay, and then we may or may not have additional witnesses. I mean, it's like kind of like an onion. So I actually think that we should see what's in the soup before we figure out how long it takes to make it. I apologize for the food analogy this early in the day, but I think the court understands what I'm saying.
Thank you, Mr. Novak.
All right, thank you, Your Honor.
Turning to the state.
I think he made a pretty good argument there. I think the judge is on his side just based on his expressions.
May it please the court. I think the first question is has the defense shown adequate basis to merit further proceedings here? whether those further proceedings are discovery or an evidentiary hearing. The reality is that defendants has already mustered the prejudicial statements, right? That's what we're talking about here, is the statements that have been made in the media. The defense has investigated that. They've reported the most prejudicial statements that they can find. And that's what the real question is do those statements violate the court's order and Rule 3.6? It doesn't really matter what other discovery shows. Maybe it does to a sanctions hearing, but certainly not to whether or not there's a contempt violation here that Rule 3.6 has been violated. So the question is, has the defense mustered that evidence and that information necessary to merit additional proceedings? And I think the best way to do that is to look at the statements and determine on their face whether there is a good faith basis, whether there is adequate evidence the defense has mustered to require additional proceedings. And
You
so I
notice
think we
he's not
start with the
denying
law.
it. That's a big tell.
When there is pervasive media that misrepresents the evidence, that misrepresents the facts, and that creates a material risk of prejudicing the rights of a party, an attorney has the ability under Rule 3.6 to correct those statements. And in fact, they have the duty, under a duty of zealous advocacy to their client, to respond. In this case, there was a tidal wave of media garnering more than 10 million views in a matter of hours that mischaracterized the evidence, that misrepresented the evidence, that misled the potential jury pool as to what the evidence was. That media, of course, reached Utah County. It was widespread, and it created an undue risk of prejudicing or tainting the jury pool. As a result, the Utah County Attorney's Office had the ability under Rule 3.6 and the duty as a zealous advocate to respond and to correct those mischaracterizing statements, those inaccurate and misleading materials. Now, when we think about prosecutors, often we refer to prosecutors as the state. And that's because prosecutors have one client, and that's the state of Utah. But it's important to remember that prosecutors are attorneys who have a duty of zealous advocacy and an ethical duty to their client, just as stringent and as rigorous as any other attorney, an attorney for a civil client, an attorney for a criminal defendant. And their duty is to ensure that their client's legal rights are upheld and defended. And when an attorney sees that their client's legal rights are attacked, that attorney's whole job, the reason they have a job, the reason they are paid by their client, is to protect and uphold those rights. Usually, this is performed in the courtroom, but occasionally it must also be performed in the media. That's what Rule 3.6c is all about. An attorney cannot stand idly by while his client's legal rights are undermined and trampled upon by mischaracterizations of the evidence, by misrepresentations of the evidence, by misleading media reports. Instead, the attorney has the duty to protect his client's legal rights by correcting that misleading statement. Now, I've mentioned the misleading reports by the media, but I want to be clear, I don't place the blame on this for the media. These are reports the media has repeated from defense counsel's misleading statements. And I disagree wholeheartedly with defense counsel's statement that their statements in their pleading was not misleading, because it absolutely was. In defendant's motion to continue the preliminary hearing, the defendant stated this: the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. Okay, so let that sink in. That's the statement they included. The ATF was unable to identify the bullet recovered at autopsy to the rifle.
Sorry, guys, I accidentally hit the wrong button.
Complete. It's not the whole truth. And as a result, it's misleading. It actually has two material omissions, not the whole by that statement is not
Back it up a
inaccurate.
couple minutes. There we
That
go.
statement is accurate. They were unable
Sorry,
to
guys.
identify that bullet to that rifle. but it's incomplete. It's not the whole truth. And as a result, it's misleading. It actually has two material omissions.
It's not
Material omission
misleading,
number
it's the
one
truth.
is that the ATF was unable to identify or exclude that bullet as having come from that rifle. Okay. And then defense counsel compounds the misleading nature of that statement by following.
Why
it
would
up with
defense-
this. The defense may very well decide.
Why would the defense say exclude when they know that their client didn't do that? That makes no sense. Guy's an idiot.
To offer the testimony of the ATF firearm analyst as exculpatory evidence. We all know what exculpatory means. That means evidence that proves he didn't do it, right? That's affirmative evidence that shows he didn't do it, right? That's the misleading nature of this statement, because it is not exculpatory evidence. If that omission, that material omission was included here, that the ATF was unable to identify or exclude the bullet, everyone would know that this is not exculpatory evidence.
Yeah, I don't think it is either.
And that leads me to the second material omission, which is the analyst reported that the
Yes,
bullet
this
was
is
a
live.
30 caliber class bullet jacket fragment. Okay, 30 caliber class. What does that tell you? Well, that excludes a whole bunch of weapons from possibly being the weapon in this case. And on the short list of weapons that are included is a 30-06, right? The weapon that was found at the scene. The reason that omission is material is because it shows that this evidence is not in fact exculpatory. This report and the testimony from this analyst will be inculpatory, because on the short list, from that bullet came from a weapon that is on the short list, which includes the weapon that was found at the scene. That's inculpatory evidence. By no stretch of the imagination is the testimony of this witness exculpatory.
You can't even tell whether it is a bullet at all. What are you talking about, dude?
It's not surprising that the media covered it the way they did, because any reasonable reading of those statements with those two material omissions leads to the conclusion which the media drew, which is that the bullet does not match the gun. This is exculpatory evidence. That's what the defense claims. Under no stretch of the imagination could this witness be exculpatory. The result of the analysis substantially narrowed the class of weapons that could have fired the fatal bullet, and the defendant's rifle was on the short list. That's the truth. Now, the media ran the story.
There's definitely a cover-up. Like I said, as far as Tyler Robinson, I don't know. I believe he was involved in some capacity, like be here at a certain place at a certain time, but he definitely was not the shooter. I'm very confident in that. But there's 100% proof of a cover-up. I would ask you to go to a good place to start would be whokilledck.com and go check out that site and just read all the inconsistencies, read the timeline for yourself, and you'll see just how suspicious everything is.
And it gathered extraordinary attention. I've noticed that the monitors are turned off. Are we still on the record? Okay, thank you. The Daily Mail ran a story garnering 22 million views on X in a single day. And the headline was, "The bullet used to kill Charlie Kirk did not match the rifle allegedly used by Tyler Robinson." Okay, the bullet did not match. Major networks throughout the country and even throughout the world picked up this story and echoed this statement that came from defense counsel's pleading. I don't lay that blame on the media. That's accurate reporting of what the pleadings stated and a reasonable inference. But they echoed that misrepresentation, that misleading news. Major news networks reported that this ATF report exonerated Robinson, that the prosecution's case had fallen apart. There were quippy headlines like, "If the bullet doesn't fit, you must acquit." And that, of course, reached Utah County, where our jury pool resides. The Deseret News, a Utah agency, had a story entitled, "How One Headline Shaped the Narrative in the Tyler Robinson case.
It's
I
not.
mention these to
The only
tell
thing
you, I'm
relevant
not
is that he went on
over-exaggerating. I'm
Fox
not
News and is
overstating
colluding with the media.
the breadth of the media coverage here and the risk of prejudicing a client's legal rights and the right to a fair trial. So what does an attorney do? You see this happen to your client. Your client's case is the evidence is being mischaracterized, misrepresented. We all know it because we know what that report actually says. We have the report in our hands. It's actually public information, but now the media is relaying the same information, mischaracterized by defense counsel, and prejudicing your client's right. What do you do? Well, you do what Mr. Ballard did. He looked at the rule, looked at Rule 3.6, subsection C, and it states, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. That's the law. Let's go through it and apply it. A lawyer may make a statement, which Mr. Ballard did, that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity. Is there substantial publicity here? Yes. 22 million views in a day. We've covered that. Undue prejudicial effect. Is it undue prejudicial effect? Yes, it is, because it's a mischaracterization of the evidence. The report does not say that the bullet did not come from that gun, which is what the media was stating, right? That's undue prejudice. It's unfair and it's not accurate.
Yeah, well, if the
And
media
that is
says
recent
it,
publicity.
but the defense didn't.
Not
you had no
initiated
right
by
to
the
go on the
lawyer or
media.
lawyer's client. Mr. Ballard didn't start this, right? The state didn't start this. This began because of a pleading the defense counsel filed in the court, right? And the rules don't require that defense counsel, in order for an attorney to respond, it doesn't require that the opposing party make the prejudicial statement to the media. All that's required is that the media is making some prejudicial statement that's reaching your jury pool and prejudicing your client's rights. So Rule 3.6 is directly on point. It allows an attorney to make statements to correct this misleading material, to correct the facts. And I would say it's not only permitted, but it's a duty to respond. As an attorney, you have a duty to watch out for your client's interests. Zealous advocacy is enshrined throughout the rules of professional practice. Comment 1 to Rule 1.3 states, a lawyer must act with commitment and dedication to the interests of the client and with zeal in advocacy on the client's behalf. When your client is being unfairly attacked, when their legal rights are being undermined, you as an attorney don't have the luxury of sitting there and watching it happen. You have a duty to stand up and represent your client. Again, usually that happens in the courtroom, but occasionally, like Rule 3.6 says, you have to do it in the media too, to protect your client's interests. And Mr. Ballard performed that duty by making a statement that accurately characterized the evidence. He had the report in front of him, and he told the media in these interviews exactly what that report said, which is how defense counsel actually characterized it today, unlike their motion, which is
I'll look into
this
that.
was an
Thanks.
inconclusive report. He characterized the evidence as the test characterized the evidence, that it was inconclusive. There was not sufficient material to compare with test-fired rounds to either draw the conclusion that it was included or excluded as having been fired from that rifle. The bullet was either included or excluded. The evidence didn't have adequate characteristics to make that comparison. That was an accurate statement in the evidence. But to show that Mr. Ballard was circumspect in his response and was abiding by his ethical rules, he did not go a step further. He could have, but he did not go a step further to explain the inculpatory nature of that report, right? What he did is he corrected the misrepresentation the defense counsel had in their pleading. He said, nope, that's not what the report means. It does not mean the bullet did not come from the gun. It means that this is an inconclusive finding. He could have gone a step further and included the other fact defense counsel omitted, which is, but the report shows this bullet is a .30 caliber class bullet which is consistent with having been fired from the rifle found on the scene. He didn't say that. He could have, but he didn't. Why not? Well, because he's being circumspect. He's abiding by his ethical duty. He's not putting forward additional evidence that proves guilt. He's just correcting the misinformation that was out there.
Well, let me stop you right there. You use the word zealously, but isn't that referring to defense attorneys to advocate for their clients? And under the rules, Utah prosecutors are to act as ministers of justice. Is there a different standard?
I would say there's a greater standard of zealousy for prosecutors than any other attorney, to be honest, because their duty is to the truth, right? Not just to represent the interest of a client, whether that's a criminal defendant or a business or a civil client.
I'm glad the judge picked up on that word too, zealously. Yeah. And also, by the way, if you're not paying attention, their defense is, oh, well, he could have said something that was far worse, but he didn't. So that proves that we didn't violate the rule.
But they have a zealous duty to their client and to the truth even, right? And that's why if Mr. Ballard had come out and said, no, the report says it came from that gun and had some kind of misrepresentation. And he said, no, I'm being a zealous advocate right now because that's what I think is going to be shown in the long run. That would be a problem. But this was zealous advocacy and a commitment to the truth here. He was representing the true nature of that report, right? The duty of zealous advocacy does apply to attorneys for the state, but they are ministers of justice. And I think it means that their duty of zeal possibly even exceeds that of other attorneys. Certainly, they're not accepted from being zealous advocates. So he did. He made that statement, a statement that accurately characterized the evidence, corrected the misrepresentation, the misunderstanding, and the mischaracterization of the evidence. He stated the test was conclusive, and he did not go a step farther or further to then pile on and say, this is what the evidence actually shows, and talk about the inculpatory nature. Maybe you're right. As a zealous advocate, maybe he could have gone a step further, but he didn't. And I think that was balancing his duty as a prosecutor and a minister of justice against that duty of zealous advocacy. Now, his second statement was he is presumed innocent. That is a statement that the Rule 3.6 and the commentary in particular of Rule 3.6 talks about. You should say that when you're talking about that somebody has been charged with a crime. He is presumed innocent, he said. The ultimate decision will be up to the jury. Those are appropriate textbook examples of how a prosecutor should talk. He then made the following statement. We believe we will be able to overcome his presumption of innocence. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder. The defense has also criticized this statement.
How is that
as a
not
statement of
prejudice?
belief, or opinion. This is not a statement of belief or opinion of guilt based on personal knowledge or experience. Instead, this is a statement tied to the evidence, which was directly relayed to rebut the mischaracterizations and the claims in the media that the state's case was falling apart, and this evidence was exonerating the defendant. This was offered in direct response to the claim that there was not adequate evidence, and the evidence that existed was exculpatory. Now, this was nothing more than the certification required by Rule 11 of the Rules of Civil Procedure. When an attorney signs a pleading, the attorney is certifying that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims are warranted by the existing law and the allegations and other factual contentions have evidentiary support. So the statement that we have the evidence to prove our case is nothing more than reaffirming and confirming that certification that we made when we filed this case with the court. To do otherwise would be unethical, to file a case that we don't believe is supported by the evidence. And this is nothing more than saying we believe that we have adequate evidence to move forward in this case. There's nothing wrong with that, and there's case law that says so, and we cited that in our brief. It's a statement tied to the evidence. Now, defense counsel has said, no, that's an opinion, and compared that with the Levitt decision. And I will tell you, there's nothing further apart than Mr. Ballard's statement and Mr. Levitt's statements. Mr. Ballard says, based on the evidence, we believe we have the evidence to go forward. Mr. Levitt says, we have reviewed the evidence the jury will never hear. And we believe this witness, in that case, the eyewitness to the murder. We believe this eyewitness based on evidence the jury will never hear. So Mr. Levitt asserted his personal belief in the credibility of a witness, right? That kind of statement would be inadmissible, would be a mistrial if that statement was made in opening statement or in closing argument, right? Mr. Ballard's statement, on the other hand, is we believe we have the evidence to prove the defendant's guilt. That's an appropriate statement in an opening statement or in a closing statement. And I should say, his statement was even more mundane than that because he said, we have the evidence. He didn't say we believe or I believe. He said, we have the evidence. And that's the type of statement that attorneys are trained to say in their opening and closing arguments rather than saying anything about beliefs. Regardless, the point is the same. This is not, I believe this witness. This is the evidence, right? That's an appropriate statement. It would be appropriate for an attorney to make at trial. And it's an appropriate statement to reassure the public that that attorney is proceeding on good faith, that there is the evidence that supports the charges, and that this misrepresentation and
To answer your question, YouTube will not let me monetize. So my way around that is right there. It's kind of like a, buy me a coffee fund or whatever. So if you donate to that, you can leave a comment. There's no limit on the comment. And then at the end of the live stream, I'll go ahead and read all you guys. Anybody who donated, left a comment, I'll read it. So that's my workaround for it. So if you want to support the stream, you can do it right there. And it's pinned at the top of the chat on YouTube and on X as well. So thank you, guys.
characterization of the evidence does not undermine the filing in this case, the filing of this case.
Well, let me ask you a question in regards to, you used the term inculpatory and exculpatory. Isn't that to the interpretation of the fact finder, whether something is or is not?
Well, ultimately, yes. And I think right now that's you for the purpose of this proceeding. But yes, ultimately it is. But I don't see how any person could say that the conclusion of the report that this round came from a 30 caliber class weapon, which a 30-06, the gun found at the scene is. I don't see how anyone could say that's exculpatory when you say that round is consistent from coming from that gun.
Well, that's your interpretation. You're saying I can't see, but do we need to be cautious in putting ourselves in place of the fact finder or making an interpretation of what the fact finder should assume it to be?
Well, of course, we need to be cautious about that, Judge, but I mean, you're the fact finder in this case. My money is you're going to say that that's inculpatory evidence. I mean, because exculpatory evidence would say this bullet could not have come from that gun, right? That's exculpatory evidence. And that's what defense counsel claimed it was, exculpatory evidence. It's a logical impossibility for that to be exculpatory evidence. I don't think there's a reasonable way to interpret the evidence to say that's exculpatory. This bullet is consistent with coming from that gun. That's inculpatory evidence. I can't wrap my head around.
It's not inculpatory.
Otherwise,
this
don't know if
guy's
defense
just
counsel
outright lying.
wants to make an argument afterwards, but I can't see it.
I'm sure they will.
I can't see it. The test was
So far, he's
inconclusive.
been all right,
The bullet
yes.
came from a 30 caliber class weapon. The weapon found on scene is a 30 caliber class weapon.
Okay.
That's what it sounded like he's
Defense
trying to
counsel has
do.
said, well, the state's only avenue, or the state's appropriate avenue. I think they're actually saying the state's only avenue from response to the statement, what I'm saying is a mischaracterization of the evidence in defense counsel's pleading. They say the only appropriate response is to respond in pleadings or contact defense counsel. That's all fine. But when it comes to responding in the pleadings, this was a motion to continue the preliminary hearing. The ATF report wasn't even mentioned in oral argument. When I responded to that pleading, I thought that's a non-starter. That's an issue that's ancillary to the core issue of this motion to continue, which was discovery of DNA evidence and underlying DNA data, right? So when I'm responding to their motion, I'm going to pick and choose what arguments are going to carry weight, and I believe will carry weight with Your Honor. I'm not going to address every single argument that's out there. And that's not, and beyond that, responding in the pleadings does nothing to correct this media frenzy that's happening.
But it was a big enough argument for you to decide to send emails colluding with all the other media outlets and then going on Fox News to publicly prejudice Tyler Robinson, right?
Out there that's just echoing this mischaracterization of the evidence, right? It just doesn't. My office is getting calls from the media after they read this. You know, they run the story, it gets 22 million views. All of the media says, wow, this is getting a ton of publicity. Let's jump on board. They start covering this. They call our office. And as an attorney with a duty to your client, do you just say, nope, I'm going to let the media run with this
Common
and continue
sense.
to mischaracterize the evidence in the case? I don't think you can do that. I think that violates your duty to your client. I think
It's not your
I think you
place
have
to
be
go on the
careful what you say,
media.
of course. But responding in the pleading doesn't protect your client and doesn't protect the jury pool from unfair and undue prejudice, which is what Rule 3.6 directly addresses, 3.6c. And that's what happened here. The rule allows response to the media coverage, and filing a pleading does nothing regarding the prejudicial media coverage in this case. I will tell you, this motion has caused the state to closely review.
So he's saying that having them fix the motion or responding to the motion would do nothing to correct the media misinterpretation, but it was the motion that started the media frenzy. So if you correct the motion, if you have them correct the motion to say what you want it to read, then wouldn't that then create another media frenzy saying, oh, it's been corrected, it's not right? I mean, this guy's he's making circular arguments that make no sense.
And to revise the way it interacts with the media. We, from the outset, defense counsel is right. We knew the rule from the outset, Rule 3.6. The day defendant was arrested, we sent letters to law enforcement agencies within the state and federal agencies as well, asking them, hey, you've got to abide by these rules, and outlining what those rules are, including the comments to Rule 3.6. We're very aware of that. We're very cognizant of that. And that's actually why we had the response we did, is because we looked at Rule 3.6. I'm assuming that's what Mr. Ballard did. He looked at Rule 3.6c and said, look, this allows me to respond. And he did. He responded as the rule allows. Your Honor, we are committed to, as we stated at the outset of this case, to abiding by the rules. We are committed to ensuring the defendant gets a fair trial, but we're also committed to ensuring that our client, the state of Utah, gets a fair trial. And when we see our clients' rights being trampled and the right to a fair trial being potentially undermined, we are going to fulfill our duty to zealously represent our client. If that means
He's
correcting the
acting like
statement
he's
in the
working
media,
directly
and if
for
that's the only way
Erica
to do
Kirk.
it, I think that that's appropriate and that's allowed under the rules. I will say that we are very cautious, and we will be more cautious in the future. In summary, Your Honor, given the state of the law, given what has happened in this case, given the state of the media and the context of the statements, and given the statements that defense has alleged here, the defense has not shown enough evidence to have additional proceedings in this case. The statement is soundly and squarely within Rule 3.6c. The statement falls within what is allowed by the case law that I cited. A statement that we believe we have the evidence to move forward with the case is appropriate under Rule 11, as well as the case law that was cited in the pleading. For that reason, Your Honor, I would ask you to deny the motion for the order to show cause. The point is well taken, and we are, as I said, have revised the way we are addressing the media, and we intend to avoid anything that could be construed as violating the court's order in the future.
All right, just a question.
I want to know what revised the order mean. I mean, when he says we revised the way we deal with the media now, I want to know what that means. Does that mean that you're not going to put it in email format anymore. You're going to use like an encrypted messaging app like Signal, where you can auto delete the messages so people can't tell that you're colluding with the media? Because that's kind of what it sounded like to me.
Two, you stated earlier that if an order to show cause, and I'm summarizing, I'm not quoting you, the order to show cause was found at the sanction stage, discovery about communications may be warranted. What's your position on the request of defense for communications, internal communications should be requested or ordered to be produced?
That's work product, Your Honor. The conversations that we have about any strategy is work product. I think there's an at issue exception to the work product doctrine. I think the amendment to Rule 16 actually gets rid of all exceptions to the work product doctrine if you read the language of Rule 16. But I think that there's, if there is an exception, it would be the at issue exception, which is, are the attorney's communications, internal work product communications, at issue in the allegation of misconduct. But I do think that, if there is a violation, that's the only way that those communications could be discoverable, would be after the fact, after a finding, and with regard to what sanctions should apply. Frankly, defense counsel hasn't shown any basis to believe that those are relevant, and that they haven't even shown they exist. And I think that they have that burden under Rule 16. But I would also say this: those are relevant to a separate issue, right? That they're not relevant to this case under Rule 16. There is no good cause for the discovery of that material under Rule 16, because Rule 16 deals with the defense's need in this case, the state versus Tyler Robinson, not defense versus Utah County Attorney's Office. So under Rule 16, they're not allowed. There's no good cause here. There's good cause to discover the statements that are in the media, but they already have those, right? Because
my take is, so far the judge has been fair. It seems like he's been very, middle of the road fair, but you have to take into account he was searched from Israel prior to the Charlie Kirk assassination. His name was searched. So that makes you wonder.
That's what's at issue here, is defendant's rights. I don't know if that answers your question, Judge.
No, I appreciate that. And final question, same one that I asked to defense. If the court were to allow an evidentiary hearing, how much time would you anticipate the state would need? Obviously, there's variables, as the defense is the moving party, but how much time would you need?
Well, probably, time to cross-examine any witnesses they have. This is the unique situation defense is going to be in, as they, what are they talking about? They're going to call every attorney that represents the state in this case. They're going to call every news agency that did an interview with any state's counsel. They're going to, they could make this thing go on for weeks if they wanted to.
They can't. The court manages the calendar, and so theoretically,
if allowed to, I should say.
All right, thank you.
So, I would think that it would be probably Mr. Ballard probably be the only witness, and in that circumstance, we'd be talking 3 hours. Probably half a day would probably do. Again, I don't think the court would be, frankly, in much better position to render an opinion than it is now. What's important here are the statements that the media has reported, and defense has already mustered those. So I don't think there's a whole lot of additional discovery that would be needed, whether it's in the form of testimony or production materials.
Thank you, Mr. McBride. All right, Mr. Novak, I did state went over by 1 minute because of my question, so you have 7 minutes instead of 6.
Thank you, Aaron. I want to go back to this court's order dated September 16th of 2025, which says, lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making, quote, an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Close quote. This court did not give counsel leave to decide whether extrajudicial statements correcting what counsel has argued are media misinterpretations of pleadings are an appropriate exception. And so actually, what counsel's argument reminds me is that there was another option that the state had. The other option which the state had, which is probably this court's preferable option, would have been to say, Your Honor, we need to have a hearing. We need to have a hearing to find out if this court believes that when the media misinterprets the content of a pleading, we can go do media interviews and send emails correcting it. Your Honor, is that an exception to 3.6 that this court sanctions? And if the answer had been yes, then there would have been a judicially supervised crafting of that. My suspicion is the court would have said, no, 3.6 is intended to allow one party to make extrajudicial statements implicitly where another party has already done so, and we need to balance the playing field. Mr. Robinson's defense team, and I've said this before, has strictly adhered to the principle that we will have no contact with any media and we will not make any statements to any media entity of any type. And in the same way that Mr. Ballard apparently was getting this influx of media inquiries, so are we every day. And we never, ever respond at all. Because to do so would be a violation of 3.6 because there is no exception under the situation here. We did not say in our pleading that the ATF report concluded that there was not a match. That is not what it says. And of course, our pleadings speak for themselves. The massive media interest in this case is not an escape hatch on Rule 3.6. It doesn't matter how much media attention there is. It doesn't matter whether it's accurate or inaccurate, as long as it's not something generated by one of the parties. That's just what we are all dealing with in this case. And there is nothing that we have done in connection with the media that justifies what the state did here or excuses it. I'm going to talk briefly about views of exculpatory evidence. The state, as Your Honor knows, has a burden to prove a defendant's guilt beyond a reasonable doubt. The absence of evidence that a fact finder might find probative of guilt is itself exculpatory. So in a hypothetical case, there's no fingerprint evidence. The state doesn't offer any. That's exculpatory. In a hypothetical case, there's no confession. The state can't offer it. That's exculpatory. The absence of evidence is exculpatory. So the ATF's inability to match is exculpatory. The state can say that there are parts of that analysis which are inculpatory. That's fine, but it is for the finder of fact, and it is well established that the absence of evidence pointing at guilt is by definition exculpatory. And so what this court obviously has is two different views on what evidence is of what value. And a devoted, well-skilled prosecutor sees one piece of evidence one way, and a diligent defense attorney sees it the other way. And the question is, what do the people in the box think about inculpatory versus exculpatory? And finally, on this discovery question, Your Honor, counsel has made references to what Mr. Ballard may have done and may have thought about and may have considered. We don't have a declaration from Mr. Ballard. We don't have any testimony from anybody in this office about what led to this play, if I may, this media play. We have argument. And that's why this court needs to investigate. And this court can't allow the state to hide behind this notion that there's no good cause for disclosure under Rule 16A4. This is a classic situation where a well-founded, not frivolous, serious allegation of a violation of this court's order in a capital case requires looking behind the curtain as to what did and did not happen. This court cannot fulfill that obligation without knowing that. And this is the case. Counsel suggested that this is not the case. This is, Mr. Robinson versus Mr. Ballard. That's not what's going on here. This is a case about Mr. Robinson's constitutional rights, his presumption of innocence, and whether the violation of 3.6 requires various types of sanctions. That is this case. It's not a different case. Thank you.
Thank you, Mr. Novak. All right. Thank you to the parties. The court is going to take this decision under advisement, and as this court typically does, we'll schedule a future hearing to render its decision, and we can discuss it at the conclusion of today's hearing. At this time, we'll go ahead and take a 10-minute recess, and then we'll turn to the other matter. Court is in recess.
That was Richard Novak, the defense attorney, one of the defense attorneys for Tyler Robinson that was speaking, by the way. Yeah, I agree with you. Whoever said this here, the defense doesn't knock this down. The prosecution will continue these shenanigans throughout the trial. Absolutely. 100% the truth. And honestly, how the judge rules on this will also set the stage for how they will act moving forward until the trial as well. Because if the judge lets this go and doesn't do anything about it, then the prosecution is going to be emboldened to continue doing it, to continue going on the media and smearing Tyler Robinson and prejudicing him. And I would really like to see some contempt motions for, the witnesses that are violating this, like Andrew Colvett. I mean, not Andrew Colvett, he wasn't there, but like Blake Neff, who was there. Roof Robinson. What happened to it? Where'd it go? What happened to it? I just lost the comment I was looking for. Did I miss it? One of my questions was the roof where Tyler Robinson was perched swabbed for evidence of spent gun powder from the 30-06 rifle? I do not believe so. I know I know they took pictures of the supposed elbow prints that were in the rocks of where the sniper was perched. But I don't think that they did any analysis to see whether there was any gunpowder residue at the scene there. If so, we haven't heard about it so far. And I'm pretty sure they did not do any GSR gunshot residue test on Tyler Robinson's clothing or on his hands to see whether he had fired a gun recently. I don't even know if they fired it, if they did that on the gun itself, because that gun, I'm pretty sure that gun could not have been fired because it had a low mounted scope, and if it had the original safety mechanism that comes on that rifle, then it would hit that low mounted scope and the safety would not be able to disengage. That's something that I uncovered a few months ago, actually. Yeah, this is live, absolutely. They're taking a 10-minute break right now, but it's absolutely live. No, the roof was flat. Where they claim he took the shot from was flat, completely flat. So there's no excuse why they couldn't have done that, to be honest. Yep. Yeah, they're on a 10-minute break. Yeah, absolutely. I'm going to try to cover as many of these hearings as I can. Between now and the trial, because it's important. People need to see this. Because the media is not telling you the truth. The media is spinning the facts. They're lying to you, and the only way, and honestly, you shouldn't, whether it be from me or whether it be from Fox News or Andrew Colbert, whoever you get your news from. You shouldn't take anybody's word for it. You should watch for yourself. You should read the pleadings for yourself. As much as I really am not liking Andrea Burkhart lately, I think she's sweeping for the feds. She does do a really good service, and she puts all the filings in the case up on her website where you can read the filings for yourself. So I would encourage everybody to do that. They're free. She doesn't charge anybody for them. But you should read the filings for yourself. You should watch the hearings for yourself, and you should see what's really going on. Thanks for the repost. Yep. I guess we could take a few minutes here. Let me see if there's any super chats. I'll go ahead and read them. By the way, if you want to send a super chat, this channel is not YouTube will not let me monetize it officially. So if you want to send a super chat, we're doing it this way. Hey, why go by? So if you want to send a super chat, you can click on the link. It's pinned in the top of the chat on YouTube. It's pinned in the chat on X or right underneath the post on. Why does this keep going off? Hold on. I don't know what's going on here. It's aggravating me. StreamYard is making me aggravated. Okay, there we go. So it's pinned at the chat. If you want to send a super chat, you can do it this way. Anybody who donates to that link right there, you can, it will bring up, hold on, I'll show you guys. So if you click on that link, it'll bring you to this page right here. You can just hit donate, and it'll let you add any custom amount you want. You could do it anonymously if you want. It doesn't charge you to do it. It doesn't charge me to do it. You can leave a tip for them if you want, but whatever. So if you leave a donation, it'll allow you to then make a comment. You can comment underneath of it. Right here, fundraiser comments. And I will read your comments out. If you donate and leave a comment, I'll read it out just like a super chat. So that's my workaround for being able to get super chats to me and for you guys to be able to support the stream. So we got a couple of them here. Let's see. I did that one last time. So we'll read, I think we got two that I haven't read yet. So Mandy Tompkins donated $100. Thank you for all your hard work. I genuinely believe through faith and unity, we the people can move the needle in our favor, slowly but surely. God bless. Absolutely. I agree. And that's what we're doing here. It's slowly moving. People are realizing that the media is lying to them. More and more people are getting their news from independent sources online. The critical thinking skills are going up in this country as well, which is a good thing. People aren't just being sheep anymore. And yeah, absolutely. I 100% believe that. And it's honestly, it's all God's work, 100%. Everything I do is guided by God. The reason I'm on this Charlie Kirk case in begin with is guided by God. I had two different, like I said, I've said this a few times. I had two different dreams where God came to me and pretty much told me this is what I need to do. He guided me, told me I need to look into the Charlie Kirk case, that something is not right. And that started me on this path. So this is a righteous mission. This is what I'm doing. This is my mission in life, my purpose, and that's why I will not be deterred. They can send as many cease and desist. They can threaten me. They can negative comments, dox me. I don't care. I'm not going to stop. So thank you for the comment. Then we have Anonymous donated $20 from Australia. Keep up the excellent work. We know there is a massive cover-up, and TPUSA is part of it. Erica is definitely a Mossad, and poor Charlie never had a clue. They always use beautiful women. Well, thank you for the comment. There's definitely a massive cover-up. We've proven that. The feds, in general, we've proven that the feds have absolutely outright lied. And besides the lying, they've done things like put out AI enhanced images that they claim to be Tyler Robinson, which look nothing like him. They put those images and they put those videos out after he was already in custody. Why else would they do that except for to portray him in the media as 100% being a suspect, trying to make him look guilty? Same thing with the Discord messages. They put them out, and there's no way they got caught faking the Discord messages, because there's no way Tyler Robinson could have authored the Discord messages, because he was in custody at the time that they were made. So yeah, they absolutely got caught, and TPUSA is a part of it. In my opinion, they are a big part of it. His security in particular is part of the actual operation, and the other people are, if they weren't part of the actual, then they are definitely part of the cover-up, Erica included. And she's definitely, I agree. I think that she targeted Charlie. We have more and more proof that keeps coming up to prove that fact, that she actually, targeted Charlie. There were at least 3 different attempts where Tyler Boyer and I guess other people tried to insert her into Charlie's life at 3 different occasions before he finally took the bait and met with her and fell in love with her or whatever. And we can also prove that Tyler Boyer knew Erica way before she met Charlie. She even says at one point in one of the interviews that she gives that Tyler Boyer was a family friend. So, yeah, absolutely. And he didn't, poor Charlie. He was targeted from the beginning. He was, I think he was tracked, from as a young child. I think he was monitored, and I think he was pushed and shifted into what they wanted him to be, what they wanted him to do. They guided him without, they used handlers around him to gently guide him without directly having to influence him. I think that's absolutely the case. So explain how defense. So what time is it? And they explain how to build a watch. Not really sure what you're saying there, to be honest. You have to give me a little more context. Cash App, yeah, it's at Project Constitution or dollar. I'm sorry, not at. It's $ Project Constitution is the Cash App. I will drop a link for you. 1 second. If I can figure out how to do this. Okay, 1 second. Okay, well, I can't figure out how to share it, but yeah, just $ Project Constitution is the Cash App. I am not monetized on YouTube because I have had 2 channels banned in the past for telling too much truth. They don't like what I have to say. So yeah, when they ban your channels, and they will not let you monetize a new one. So that's something that I've had to deal with. I've gone through that with TikTok. I've had multiple channels banned on TikTok, multiple channels banned on YouTube. The only place I haven't been banned yet is X, but the way things are going, I wouldn't be surprised if that's coming soon as well. All right, we're back on, guys.
Electronic media coverage. We do
Oh,
anticipate
sorry.
that will happen.
All right, let
But,
me back it up a
That was our
few.
primary concern about the exhibits.
Please plan accordingly. And
Sorry
as
about
this
that,
is
guys.
defense's motion, defense will proceed first
I forgot to unmute it.
and turning to defense. Ms. Visser.
We're only a couple minutes behind. It's not a big
I
deal.
can tell you I am definitely not taking an hour here.
All right. Those are words that every judge wants to hear.
It's not the attorney 5 minutes, but it definitely won't be an hour.
All right. Thank you.
So yes, Your Honor, the two issues before the court in this motion are the handling of the exhibits at the preliminary hearing and the motion to close the hearing itself or portions of the hearing. I'm going to work backwards because I actually think the state and the defense are mostly on the same page about the exhibits. It seems that the state does not intend to offer the exhibits in such a way that they will be viewable by the gallery. That was our primary concern with the exhibits during the hearing and making those publishable online through the live stream or recording. That issue is not before the court at this point. I don't believe there has been a request for electronic media coverage. We do anticipate that that will happen, but that was our primary concern about the exhibits and how they are kept in the record, if they are kept in the record. I know that standard protocol is that they are withdrawn after the preliminary hearing. That's what I anticipate to happen here. However, if for some reason they need to remain in the record, we have provided a detailed table to the court of what is already categorized under the rules of judicial administration as private, protected, and safeguarded. And we're asking the court to ensure that the records are held that way if the state desires to keep them in the record for any reason. We don't believe there is any reason for that. If there is post-preliminary hearing litigation where we need to reference exhibits, we'll handle that at that time in the appropriate way, make sure they're classified according to the rules.
Okay.
So I think that actually addresses that concern. The other concern, of course, is closing the preliminary hearing, which is a little bit more nuanced and is tied in some ways to the other motion that is not fully briefed yet about the use of reliable hearsay in a preliminary hearing in a capital case. I'm going to try very hard not to delve into any of that. I know that the state still needs an opportunity to respond. Going to the two factors from Kearns, I'll address those. The first is the evidence relevant to the nature and extent of the adverse publicity that may be generated from providing evidence in an open setting in a preliminary hearing. Now, we've overwhelmed the court, I will say, with the adverse publicity in this case. We had a whole hearing about it. We submitted lengthy briefing, lengthy presentations, copies of all of the videos. So this court, I think, has a very good idea of some of the media that is being generated around this case. I also think that the argument that we just had demonstrates how sometimes the media can misconstrue the evidence in one way or another, and that can get into the jury pool. So our goal here is to prevent that from happening by avoiding publication of evidence before there has been admissibility determinations. There will be litigation about the admissibility of a lot of this evidence. There are chain of custody issues that will have to be addressed that are not appropriate for the prelim. There is 702 and Daubert issues that will be addressed as far as expert reports and testimony. And most of the preliminary hearing, as far as we can tell, is going to be based off of reliable hearsay. They're calling 5 officers to discuss a very extensive investigation, basically throughout the state of Utah. The reports are lengthy and contain lots of statements from other officers and people that collected evidence and people that talked to witnesses. And unfortunately, we're not in a very good position right now to know what of that testimony is going to be based on personal knowledge versus reliable hearsay from other officers as defined by the rule. So our solution what we see is closing the preliminary hearing and this court thereafter providing a transcript of what occurred during the preliminary hearing that can account for all of the evidence that wouldn't be admissible at trial. That's the solution that we're proposing here. That's the only way we see that we can protect our client's right to a fair trial and avoid evidence getting out that potentially is going to be challenged in the future and may not ultimately be used or admissible at trial. So that also addresses the second Kearns factor. I also wanted to note, just for the court's understanding, when we talk about Kearns and we talk about Archuleta, both of these cases happened at a different time, before the use of reliable hearsay was allowed by the Utah Constitution in the way that it is now. So when we're talking about those cases and their discussions of prejudice and what open and closed looks like under those circumstances, they were very different. There were more witnesses testifying as to their facts as opposed to hearsay from other individuals. And there was more opportunity for cross-examination and the exercise of our client's right to confrontation. So now we're dealing with basically just a presentation of evidence from the state. And again, without any determination about admissibility at trial. So we are asking for that solution. We think the landscape of the evidence at this point versus those prior cases, while they are still, the guiding procedure for this court to follow, we believe the instances in this case, the circumstances of this case, the media presence in this case, and how the media has already, in some instances, taken information out of this court and misinterpreted it and facilitated misinformation about the case. We believe the only way to really prevent that is to control what's coming out of this courtroom. So that is why we're asking to close portions of the preliminary hearing if we can narrow it down. Honestly, I think that's a question only the state can answer, or the entirety of it, and we can pick through it after.
Well, so let me stop you right there. So in looking at Kearns, we have to align with the narrowly tailored, like simply saying closing the whole hearing. I don't think that would conform with narrowly tailored and saying, let's just close the whole thing and then pick it apart afterward. Wouldn't you agree that that's a bit broad? And that kind of, that's not the intent of the case law or the rules, that we get to just shut it all down and then figure out afterward. Or do you have a different interpretation?
Well, Your Honor, we've kind of talked about different solutions here, but the alternative is we essentially make objections as we go through the hearing, which will probably take quite a bit of time and extend the proceedings significantly. So if that's the preference, we can absolutely do that. I do think that it would interrupt the flow of the evidence and the presentation before the court to do it in that way. But if that's the preference, we're also open to that solution. But our concern, again, is that a bunch of inadmissible evidence is going to be presented without any sort of testing before it is presented and put out into the world to the jurors and biasing our client's right to a fair trial. Does the court have any additional questions?
No.
Okay, thank you.
Thank you. Mr. Grunander.
Thank you, Your Honor. The state has tried to make it abundantly clear throughout this process that we favor open hearings so that the public can trust what happens in this courtroom. And public confidence increases when people can see justice at work. So that's our general argument. This, in many respects, is largely the media's fight, Judge, but the state is interested in weighing in on these issues here. We've talked a little about the Kearns Tribune Court. And it's clear from that decision that the public, including the media, possesses a constitutional right to access preliminary hearings. And the overall question there as far as closure is there a realistic likelihood of prejudice to a defendant's right to a fair trial? That's the overall question. And then we get into the factors that the court should consider, which are, will the evidence shown during the preliminary hearing create such negative publicity that it's impossible to hold a fair trial because an impartial jury cannot be seated at some point in the future? And the second question is important. The second factor speaks to, are there feasible and effective tools available to this court to ensure a fair trial? And we've had extensive arguments about pretrial publicity in this case. We've talked about voir dire. We've talked about extensive jury questionnaires that can be used as well. And as it applies to here, we've talked about the idea of shielding the public from some of the exhibits that are going to be offered into evidence. So let me just kind of pivot to that. We do favor, Your Honor.
You mean hiding, not
the
shielding?
judge- we favor, Your Honor, denying access to the public and the media from physically handling the exhibits and copying the exhibits that are admitted during the preliminary hearing. And the reason for that is expressed in the Archuleta case. And the language there is that we believe that allowing the media or the public to physically inspect or copy these exhibits may disrupt the efficient performance of justice, hamper judicial interest, or jeopardize defendants' right to a fair trial. And that is because we have not yet tried the case. Those are likely exhibits. Many of the exhibits will be used at the trial at some point in the future. And having the media access those and try the case in the public, if you will, I don't think serves the administration of justice. So I think we concur with the defense with respect to that. Now, when it comes to the closure of the proceeding, that's where we differ, I think, significantly, Judge.
Yeah, the last hearing was to blanket ban cameras from all hearings moving forward. And the judge said no. And he said it has to be on a case-by-case basis, meaning for each hearing, they have to file a motion if they want to ban cameras. So, of course, Tyler Robinson hearing, instead of focusing on trying to defend Tyler and poke holes in the state's case, they're spending most of their time on trying to ban the public from seeing the case, which is crazy.
Because the public has a right to be present, including the media, as articulated in Archuleta, they have a right to report on all that occurs there. So there's a difference between the public being present for the hearing, observing the hearing, the media being present and reporting on the hearing, and having access to the actual exhibits. But there's real merit in the public being invited into this proceeding to watch how it plays out, to see the exhibits introduced into the evidence. They're allowed to listen to the arguments between the parties on the admissibility of it, the arguments at the close of the hearing on whether the state's met its burden to bind the defendant over for trial. And that's part of opening these proceedings, making them transparent so that the public can trust the process, what happens in this courtroom. If the court were to close the preliminary hearing, the court would necessarily be making the decision to limit electronic media coverage. So I think that Utah Code of Judicial Administration Rule 4-401.01 is in play. And the court's going to have to undertake that analysis if the court is to close this hearing or even close portions of it. And there's a number of factors that the rule asks the court to consider, some or all of these factors. And some of them clearly stand for this idea that it should be opened. The media should be allowed to cover these proceedings. For example, the adequacy of the court's facilities for electronic media coverage. Check, that one is satisfied. The public interest in and newsworthiness of the proceeding. We all know the newsworthiness of these proceedings. The potential benefits of allowing public observation of the proceeding through electronic media coverage. Again, we think that opening these proceedings It creates confidence in the system. Questions of whether there is a reasonable likelihood that electronic media will jeopardize the safety or well-being of any individual. I don't think that's in play here. Whether there is a reasonable likelihood that electronic media coverage will jeopardize the interests or well-being of a minor. I don't think that's in play. Whether there is a reasonable likelihood that electronic media coverage will constitute an unwarranted invasion of personal privacy of any person. Again, I don't really think that's in play here, Judge. So I don't think that the presumption that the media can be present and report on these proceedings has been overcome under that rule. Reliable hearsay. Judge, reliable hearsay is a staple of preliminary hearings. It's important that we all recognize that this is a probable cause hearing, akin to a grand jury in many respects. Does the state have enough evidence to move this case forward to trial, forward to 702 hearings and different challenges on the evidence? And so that's why reliable hearsay is allowed.
Well, Mr. Grunander, and I know that this is a subject of the other motion, and so I want to,
Sure.
Both sides will have ample time to argue that, and I don't mean to interrupt you, but just that's being reserved for a different hearing. And again, don't mean to interrupt your flow, but that's a decision for a different day.
Fair enough. I'll pivot to my main point in bringing up Rule 1102, Judge.
Okay.
And that is that if this court were to close the preliminary hearing or even portions of the preliminary hearing because of using reliable hearsay, that would essentially swallow the rule, swallow the constitutional rights that the public has to be here and to witness these proceedings. So I just think that that's an absurd result, Judge, that a procedural rule that allows for evidence to come in would negate the constitutional rights of others. So that's my primary point with respect to this motion, Judge. It's also, and I make this point in our written pleading, but the practical effects of introducing evidence at a preliminary hearing is different than that of trial. We oftentimes don't publish the exhibits like we would at trial to a jury, where it's broadcast up on a screen for the jury and the public to see. Many of the exhibits that will be introduced at this preliminary hearing through 1102 are like an autopsy report that would not be published. Lab reports would not be published. Written 1102 statements that the court will receive will not be published.
Why wouldn't
And
they be
so
published? That's ridiculous.
This idea of prejudice is mitigated for that reason alone. And then on top of that, of course, we would ask the court to essentially seal those exhibits and not allow the public and the media in the future to inspect them and make copies of them. But again, I believe the public, well, the law is that the public has a right to be present, to observe the proceedings, hear what's going on, watch the arguments, etc. And while some of the specifics of those lab reports, for example, will likely come up in argument, perhaps on maybe the admissibility of it, if objections are raised, or certainly at the end of the hearing when arguing bind over. There's a difference between being present in the courtroom and hearing those arguments and hearing references and even partial quotes of that evidence versus examining physically and copying those exhibits and having those. So again, I'm going to defer. The media is present. It's my understanding that they want to be heard on this motion. This is largely their fight, but again, the state wants to give the public the opportunity to critique these proceedings and to have confidence in what's happening in this court. And I'll submit it on that, Judge.
Well, I do have a question for you, Mr. Grunander. Being that it is the state's burden to present the evidence at the preliminary hearing, do you anticipate any of the evidence being presented that would require a closed portion of the hearing? And if so, what mechanism do you anticipate or you would advocate for to ensure that it's handled appropriately?
Judge, I don't anticipate testimony that would require closure for it to be admitted at the preliminary hearing. Again, there are going to be exhibits presented. For example, we have 2 videos. We have 5 officers that are subpoenaed to testify. With respect to 1102, we expect to rely heavily on 1102 in presenting our evidence. But these are officers who will testify to personal observations from other officers. They will also provide some foundation.
This is
for
the
exhibits that
judge's
will come
first
in.
case ever, by the
We do
way.
have one video recorded.
He was appointed to the bench
1102
just
statement
before
from
this
Lance
case.
Twiggs. But I don't believe there's any reason to close that portion of the preliminary hearing. And Your Honor, we have provided Your Honor with the physical copies of those exhibits, and the electronic copies are on a thumb drive, which has been provided to the court for your review as well.
Well, just to be clear, I actually had the exhibits returned because I wanted to wait till the prelim to look at the exhibits, and I haven't. And a lot of what's been proposed as potential evidence, the court has explicitly not viewed, even if it's in the public sphere, just so the court can go in with a clear mind. So I appreciate
Okay.
that, but I just want to put on the record, I did note that folder, and I appreciate that preparation, but the court has not, and it will not review it until the prelim to ensure that, you know, as a magistrate, I want to make sure that I go in only considering what's been properly admitted, and not to say you wouldn't properly admit it, but I just want to go in with that clear mind and only considering what has been admitted into evidence.
Okay. Should the court change its mind and wants to view it beforehand to make a
Sure.
determination, that information and evidence is available.
I appreciate that. Thank you.
There are 2 videos.
He's trying to
as well
prejudice the
answer
judge
Your Honor's
right there.
question.
That's
There are 2
crazy.
videos which depict the killing of Mr. Charlie Kirk that were taken by people that were present at the event. Those are sensitive in nature.
Mhm.
You're watching the death of another individual, the violent killing of him. I wouldn't describe them as horrific. It's not a torture killing, as was described in the Archuleta case, but that material is sensitive. And so if that is received by the court, it would need to be published at least to Your Honor.
Sure.
And if it's in an open court proceeding, the monitors could be turned away from the public's view so that that's not viewed, for example.
What? Why would they want to hide the footage of Charlie's, of them, why would they want to hide the footage? It's been all over online, everywhere. Like that's like every single bit of footage that you could possibly imagine has been all over the internet, millions and millions of views. Everybody has seen it. Why would they try to hide it now? That makes no sense. I will say the only thing we haven't seen yet is the stuff that Turning Point is hiding, and they still refuse to release.
But I don't believe that the hearing needs to be closed, or there's even portions of the hearing that really needs to be closed. Again, I think there's a middle ground here where the public and the media can be shielded from some of the sensitive stuff, but it doesn't need closure.
Thank you. Thank you, Mr. Gernander. All right, to Ms. Visser. Or, to the media, and then we'll return to you, Ms. Visser.
They're all actors. This is nothing but a show trial is what it is.
Thank you, Your Honor. The court has a challenging task when it comes to requests to close portions of a hearing. The court knows the distinction that's been drawn. When the court ruled on the motion to exclude cameras, it made note of the fact that we were at that time in a bit of a different world. At that point, we were not talking about a constitutional right to access. In this case, we're back in that world where we are, right? Where the public has a constitutional right to access court proceedings and court documents. When we were talking about the question as to whether or not the public would be present for the cameras motion before, the state said something in its briefing, and it said, different hearings operate different ways. And with respect to certain hearings, we're not sure where it falls on the spectrum, how strong the recognized constitutional right of access is for that hearing. Preliminary hearings are one of the small categories of hearings in Utah and nationwide that are expressly recognized as set apart. It's criminal trials, and then what comes next is preliminary hearings. And there's a reason for that. The lead case that the court has seen and will see more of is Press Enterprise. That's a U.S. Supreme Court case, 478 U.S. 1. In that case, the court was remarking on a 41-day preliminary hearing that had taken place in California and wanted to make sure that the public had access to that, in that case, to the transcript of it. And so the reason is that preliminary hearings are often the sole occasion for public observation of the criminal justice system. In a lot of cases, that's as far as it goes. That's all the public may have the right to see. And stripped of the opportunity to participate and watch that, the public may get no insight at all. Recognize in that case something that this court has recognized, that access into a preliminary hearing and to other court proceedings enhances both the basic fairness of the criminal trial and the appearance of fairness.
This guy, by the way, I'm pretty sure is the lawyer representing the media's interest, representing all of our interest in having the trial open.
So essential to public confidence in the system. We aren't relying on a U.S. Supreme Court case alone, as the court knows. In Kearns Tribune, this has been brought into Utah. And we were told something similar. In addition to kindling public misperception and eroding public confidence, closure of significant pretrial proceedings, like a preliminary hearing, perpetuates general ignorance and cuts off public knowledge necessary to a full understanding of the criminal justice system. It's really important that the public be allowed to access proceedings like this one. We've heard the parties reference, the defense reference at least a little bit, part 2 of a Kearns Tribune test. The idea here is that when you are seeking a departure from a recognized constitutional right of access, the party who's seeking closure, in this case the defense, needs to come forward with specific evidence about the thing that they're asking to seal and or close, and what the interest is that would justify that departure from the constitutional norm. As the court certainly recognizes, if there is going to be some sort of closure, the court has to go say in a written finding, here's why I am closing this piece off. It's why this wait and see approach, let's just get to the morning of the preliminary hearing and make this decision, won't work. How at that time would the court be able to say, I'm going to go make a written closure finding, balancing these interests, if you're asking me to do it on the fly? It means we need to do it now. And that's why this idea of listing every line of testimony, every bit of witness time on the stand, every potential exhibit, and saying, let's seal and close all of it for 5, 6, 7, 8 different reasons, makes for a real mess, right? It makes a real challenge to say, so to be clear, you want me across 34 exhibits and 8 potential objections to make written findings that justify each one of those. I can imagine a world, and I know the court can too, when there is an exhibit, a portion of a bit of testimony, where it may be truly unique and special enough that the court would then need to hear a specific argument. But the burden to do that is on the party seeking closure because of the constitutional rights at issue here. In order to do that, the party seeking closure needs to have evidence of 2 types. One, evidence relevant to the nature and extent of adverse publicity that may be generated by the open pretrial proceeding. So I need to come show you what it is that's so problematic about it. And then, as the court recognized, specific evidence relating to the availability, feasibility, and efficacy of alternative means of selecting jurors and conducting the trial to assure the integrity and impartiality of the jury. That's from page 523 of Kearns Tribune. You need to show up with both those types of evidence. The court knows what the normal alternatives are because the court has thought through those and mentioned those in its rulings before. If there is evidence, as it should and as it can under our system, that becomes public during these pretrial proceedings, you hear a witness testify about something, you hear about a piece of evidence that's introduced. The expectation is that to the extent that that has some potential prejudicial power, you deal with that through these normal tools of jury selection, an expanded voir dire, detailed jury questionnaires, things of that sort. We mentioned in our briefing what you often see in Utah cases is they say by the time you get to trial, potential jurors may say, I remember hearing something about this case, but I no longer recall any details, right? And I certainly feel comfortable being able to set aside any prior knowledge that I had and focus solely what is in front of me at this case. That's the preferred narrowed means. So in order to justify a sealing, a party seeking that sealing or that closure needs to come and say why that isn't enough. Why for this specific piece of evidence, why for this specific stretch, that won't work. Again, I can imagine a world in which a showing like that is made, but we are nowhere close to that as far as granularity, as far as satisfying that burden, as far as with specificity here. I do want to mention briefly Archuleta. Both sides have talked about this different type of request, right? I want to stress that in most cases, and in this instance, what the media is asking for is essentially occupy the role that a member of the public would occupy if they were sitting in this courtroom. So if things are said out loud or presented to the court in order to justify or try to meet the burden of a preliminary hearing, the press, acting as a proxy for the public, would have the opportunity to watch, listen, consider, and report on that. Court knows that if a member of the public, as much as we appreciate them being here, said a preliminary hearing, that piece of evidence up there on the stand looks interesting to me. Can I come up and hold it? The court would say, no. We're trying to preserve the integrity of this proceeding. And so you can listen to what you're seeing in the courtroom, but you can't come touch it or copy it or take it home with you, right? That's what was at issue in Archuleta. There were some pieces of physical evidence that there had been a request by the media to actually handle, inspect, copy. And in that court, the court said, well, we'll treat that differently. We think there's some different considerations at issue when you are asking to physically handle exhibits. Nothing like that is at issue here. The press has not in its briefing and does not here today seek to be able to do that type of hands-on examination of evidence or copying that was at issue in Archuleta. What the press is asking for here is what the press so often asks for, which is we are a proxy. We are here to help assist, to be the eyes of the public, to help them observe those sorts of things. So for that reason, the language in Archuleta that says there's no constitutional right to access the exhibits in that way is simply not in play. It's simply not before the court. And the court does not need to reach that question of what if somebody asked to hold or copy one of the exhibits that's being introduced at this preliminary hearing, because no such request has been made here. I know that there's been a lot of hypothesizing about what will happen with these exhibits, a lot of exhibit-specific arguments about Rule 4, 202, and various subcategories of private or protected justifications. I don't want to get in the weeds here. We could go through exhibit by exhibit, argument by argument. But what I want to stress, though, is that I think that the cleanest path and the only path that the court is really equipped to be able to take at this point is to be able to say, listen, what is presented in that hearing, absent any sort of narrow showing of closing or sealing a specific moment, should be open. The press should be able to see what a member of the public would be invited to come in and see on that day. And that would be discussion of these exhibits and being able to hear the testimony. The fact that some of this information may eventually be inadmissible does not constitute a link to showing reasonable likelihood of prejudice at trial that would deprive a defendant of a fair trial right. Party cannot simply say it's possible that at a preliminary hearing, some evidence that is eventually deemed inadmissible may be presented. As the state pointed out, that would be true in every case. That can't be used as a basis for closing or sealing a hearing in this case. The stakes here are high. Kearns Tribune says it bluntly. Democracy blooms where the public is informed and stagnates where secrecy prevails. Closing these proceedings to the public will not improve the efficacy of these proceedings. In the Press Enterprise case, they went 41 days in order to make sure the presentation was done appropriately. The court has no intention of using 41 days in this case, but saying it might slow things down if we had to be careful every time we close the proceedings is not a justification to close the entire proceedings. It might slow things down. It may force parties to, on occasion, say, let's talk about this specific piece of evidence. But because that's hard, doesn't justify saying, let's close the entire thing. The court has correctly not taken that path in the past, should not take that path now. Thank you for hearing us, as always, Your Honor.
Thank you. Ms. Visser.
I think he made sense. He made a pretty good argument there. Oh, Tyler's
Thank you,
actually
Your
in
Honor.
person. That's awesome. First time I've seen him
I
today.
just want to address a few things. First, I would propose that there could be a solution whereby we have portions that are closed, like preemptively closed, and portions that are preemptively open if necessary. I just also want to caution the concern about admitting some of these exhibits that are protected, private, safeguarded, and the testimony that may accompany those being admitted. It sounds to me like the state doesn't intend to essentially do an end run around those classifications and have people describe those or read those out loud, and that would be our preference as well, because those are classified as private, protected, and safeguarded. So we would ask for that solution to be implemented as well.
And to that, just as you're talking about that, I'm just kind of thinking out loud. And I always encourage parties to see if there's any stipulations to exhibits. You know, for jury trials, I always encourage the parties to get together and to see. And I'm not saying you need to, but perhaps that could be something that would help resolve some of these issues. If there is that removes the need to go into detail or even to go into what could be problematic foundation laying again. But I'll leave that to the parties. The court is not intending to insert itself in those conversations.
No, that's a good suggestion, Your Honor, and we're definitely open to having those conversations in anticipation of the prelim to make things simple and move quickly, for sure.
Okay.
As far as the Rule 4-401.01, the electronic media coverage, I just want to reiterate that issue is not before the court right now. There may come a time when we need to address that when the media files their request, as they inevitably will. This court made a detailed order about how we are to address that, and so we'll address that at that time. I don't think it's a basis for this court to deny our motion for closure. It is a very different issue, right? Whether or not the media are allowed in the courtroom versus filming and live streaming is very different. So we did not go through those factors. Potentially we will in the future. So, Your Honor, we are asking for some reasonable solutions to prevent information being out in the public from the preliminary hearing that likely will not be admissible at trial. Hearsay from other officers is obviously not going to be admissible at trial. Those individuals will have to testify. 1102 statements, clearly not admissible at trial. Those individuals will have to appear. We will have the right to confront them, cross-examine them. So we're asking the court to take measures to ensure that that information is not published from the preliminary hearing. That is our primary concern with the motion to close. So we are asking for that. Thank you, Your Honor.
Thank you. All right. All right. Thank you to the parties. I appreciate the argument and briefing that was done. Acknowledge your hard work and diligence. The court will take both matters under advisement and issue a ruling on WebEx. And counsel, I want to check with you. I have, I anticipate approximately 30 minutes as I've done in the past in either a morning or afternoon setting on June 1st. Is there a preference of the parties?
So June, we're not going to get a ruling either way on either one
Mr.
of these
Nevada.
things they argued today
Only
until
that I
June
presently
1st
have a
now,
hearing
apparently.
Scheduled for the afternoon, late in the afternoon of June 1st, California time.
All right.
That's all.
And first, is there, we've had a
Oh, big time.
traditional way of doing this.
I'm
but
shadow
do the
banned
parties
all over the
have any
board. X,
objection
YouTube, all
for
of
my
them.
ruling to be on WebEx to accommodate all the parties?
Not for Mr. Robinson.
All right. And
The morning of June 1st would be preferred by the state.
all right. How about 10 a.m. on June 1st for a WebEx hearing? And again, I wish to be thorough to defense. What is your election as it relates to Mr. Robinson for that hearing?
Your Honor, if he could just be present with no video, just like in
Okay.
the past. Thank you, Your Honor.
All right. All right, let me look to. All right, so I would like to set an in-person hearing for defense's motion to challenge the constitutionality of the Utah Rule of Evidence 1102, Utah Constitution, Article 1, Section 12. And if granted by the court, if I rule on June 1st for an evidentiary hearing, I would also like to hold that at the same time. Again, the court is not making its mind up. It's just indicating that if the court elects to hold that hearing, it would be on that same date. And we're looking at June 12th. And the availability of the parties.
So now he's gonna rule on the motion and do an evidentiary hearing on the same day. And it sounds like he is leaning towards an evidentiary hearing.
All right. All right. And what I'm trying to do is address these issues prior to the preliminary hearing and allotting time to take the argument on consideration. The court intends to give serious thought and consideration to the motions and to the oral argument. So I'm trying to space it out so the court can do that and issue its ruling prior to the preliminary hearing. So for the June 12th, we'll start at 9 a.m. and we'll set aside the majority of the day. On the day of the hearing, I'll state the time constraints that we have, but as done today by counsel, I appreciate your succinct arguments. It is appreciated, and that reflects your experience and professionalism as well. With those two dates set, June 12th at 9 a.m. for the evidentiary hearing on the motion and potentially evidentiary hearing for the order to show cause, and ruling on June 1st, 2026 at 9 a.m. on WebEx for ruling on today's proceedings. Do either party wish the benefit of the record at this point?
I'm sorry, you said 9 a.m. on the first? I thought the court said 10 a.m. on the first. Is that right?
I did. I wrote down 9 and I said 10. So it is 10 a.m. on June 1st. Thank you for that clarification. And on June 12th at 9 a.m. All right. And as it relates to June 12th, as it relates to Mr. Robinson, what is the request of defense?
We would ask for an order to transfer.
All right. All right. I'll go ahead and grant that. All right. Unless there's anything further, again, thank you to the parties for being present today. And the court will be in recess until June 1st at 10 a.m.
All right.
Okay, guys. So it looks like the judge is holding off. He is not issuing his ruling on the motion for contempt against the prosecution for going on Fox News and colluding with the media, sending emails colluding with the media. So he's holding off on the ruling for that, and he's holding off on the ruling whether to ban cameras or not until June 1st. June 1st at 10 a.m. There's going to be an online WebEx, like a Zoom hearing, where he's going to make his rulings then. It sounds like to me that he is leaning into definitely having an evidentiary hearing, that he thinks there's enough evidence there for an evidentiary hearing on the motion for contempt. And that's actually really good news, because if he does that, then the defense will be able to get discovery of the communications between the prosecution and all these media outlets like Andrew Colvett, like Fox News, TMZ, all these media outlets that they've been colluding with. The defense is going to get to be able to get their communications to prove that. And I think once they get those communications, that it's going to show just how much they've been colluding, even more than the defense thinks. And that's why they were fighting so hard to try to, that's why the prosecution was fighting so hard to try to pretend like, oh, well, we didn't do anything wrong. So yeah, so I think that's good news. And if the judge does, on the first, if he does issue his ruling approving for a preliminary, I'm not here. If he does issue his ruling approving an evidentiary hearing on the motion for contempt, then he's saying that that will then be, then that hearing will be on June 12th. And it will be an all-day hearing starting, I think he said 9 a.m. and lasting all day. So June 1st will be the next hearing that we have here. So make sure you come back for that, 10 a.m. on June 1st. I'll stream that if hopefully I'm available. I plan on streaming all these hearings as long as I don't have anything that I'm doing that I can't. But so the next hearing will be June 1st. So come back and look for me then. And June 12th will be so they're the next two hearings to pay attention for. Wish Tyler would stop chewing his fingers. I'm not sure if he is medicated. I didn't notice that myself. I wasn't really paying attention to him. But yeah, I mean, I'm sure that they've probably got him heavily medicated in there. You know, which is sad, honestly. Thanks for the theater of absurd. It is. It's 100% absurd. Everything they do is absurd. This is nothing but a show trial. I mean, they have no evidence against Tyler. This is just a show trial. You hear the mom's side of his family has a hereditary bone disease. Not sure. Where did you hear that? I haven't heard anything about that. The kind that would make it hard to jump down 5 meters and keep running almost immediately upon landing. Maybe that condition requires medication. You know what? If that's the truth, then that's certainly a possibility. I would like to look into that. I haven't heard anything about that. So, you know, if you could either DM me or email me, let me know where you heard that or direct me to that source. I would appreciate it. You can DM me on X, or you can email me at projectconstitutionvideos@gmail.com. I do know that Tyler Robinson has a lazy eye, which would make it pretty difficult for him to, you know, zero in and fire that supposed rifle from the roof of the Losi Center hitting Charlie Kirk. So that's one thing that would preclude him as the suspect. I know that much for sure. Magistrate judges are very special. Okay. Thank you so much for streaming this for us. Yeah, absolutely. Like I said, it's important for the public to see this stuff themselves. It's important for people to make their own informed decisions, because the media has been lying to you. And the only way that you're going to know that is if you watch it for yourself, and then you can see. It's very sad. I hope he gets a fair trial and the evidence is presented. Yeah, we'll see what's going to happen. I don't think I honestly, he's already not getting a fair trial, because they've already tainted the jury pool, between the prosecution going out there talking a bunch of ish on him, between Andrew Colvett and Blake Neff and all of them talking a bunch of ish on him, between Trump, going out there saying he needs to get the death penalty, and the prosecutors talking, and he's already been prejudiced. So there's the jury pool's already tainted. So I don't see him getting a fair trial. And another thing is, they don't have any actual evidence against Tyler Robinson. So I don't see this actually going to trial. I really do fear that they are either going to, Epstein him, suicide him while he's in there, or they will, condition him enough to sign a I'm blanking on the word of it. Sign a plea agreement, to sign a plea deal, and and admit guilt or whatever. So that's one of the two things that I think are going to happen. I hope I'm wrong on that, but I really do fear that is where we're headed. Yeah, exactly. That's my whole point. Yep. Yeah, and he's actually made statements that are complete lies. Like he said that, like, he was on, I forget, Fox News or one of these shows, but he went on there saying, that Tyler Robinson's dad turned him in, and the reason he turned him in was he saw the video, or he saw the pictures of the rifle, and then he saw the video of allegedly Tyler jumping off of the Losi building and running away, and immediately knew that was his son, and that's what made him suspicious of Tyler, and why he turned him in. Well, we know that's a lie for two reasons. One, there was never ever been a picture of the rifle put out in the media. The picture that they put out is a stock photo. It's not even of the same firearm that they claim he had. And it's been admitted that that's a stock photo, that the media just put a stock photo out. So there's no way that the dad could have recognized Tyler's rifle from a stock photo on the media of a gun that was not even the same type of the weapon that Tyler allegedly owned. So that's the one thing. And the second thing is, they're saying that he recognized Tyler from that video of him jumping off the Losi Center roof. Well, the problem with that is they didn't release that video until after Tyler was already in custody. So how did the dad see it and recognize his son if they had already released that video? I mean, how did they see it and recognize his son if that video hadn't been released yet? Makes no sense. And secondly, even if the video were released before and somehow the dad saw it, it's so far back, the person on film looks like tiny, like a little ant, like a little bug. There's no way that you could even make out who it is. If it, you can't even tell it's a person, honestly. So there's no way to recognize that is Tyler Robinson. There's just no way. It's complete nonsense. It's all lies. Like, yeah, exactly. This person right here. It's all lies. That's exactly right. It's all lies. And they've been caught lying. That's why I say there's a cover up, and we've proven a cover up. The FBI has been caught lying. Turning Point has been caught lying. They've all been caught lying. They've all been caught with their pants down, lying, outright, blatantly lying on this case. That's a cover-up by design. By definition, that's a cover-up. Yeah, he's a patsy. Absolutely, 100%. Erica Kirk wants this to be a speedy trial. If it were my loved one, I don't care how long it took. I would want the truth. Exactly. And that's honestly, that's my point. She's participating in the cover up. Like when I say she's guilty, this is what I mean. I'm not saying that she 100% is the one that, Charlie, although I do think she was involved in that. I don't necessarily have definitive proof of that. What I do have definitive proof is that she participated in the cover-up of them murdering her husband. Absolutely, 100%. And part of that is she's orchestrating behind the scenes all of this attacks against us, all of this PR that they've been doing, for one. And secondly, like you said, she's like the motion for a speedy trial and filing on the case for all that. She's trying to hurry this case along. She doesn't want them to do a proper investigation. She just wants it swept under the rug and move past it and move forward. She doesn't care that the real killer is guilty. All she wants is to convict the patsy and move on and put it behind her. That's all it is. It's disgusting, honestly. It makes me sick. And that's one of the reasons why I just can't stand Erica. Yeah, exactly. COVID 2.0, 100%. Matter of fact, let's play. I'm gonna play that. I think that was a really, really good comparison that she did on her show yesterday, comparing Erica Kirk to the COVID vaccine. And I'm going to play that before we get off, because I think that was really, really a good comparison. Oh, it says, Project Constitution, I replied to your ex post with more content for the bone disease claim. It's based on an obituary of someone who may be related to Tyler through his. Oh, okay. Very, very good. Thank you for that. I'll take a look at that. So yeah, let me go ahead and pull that up. I want to, this comparison that she made, great comparison. I want to go ahead and play this for you guys. I think it's actually really important, and it's very, very accurate. It's like spot on. What she said is completely spot on. All right, give me a second while I pull it up. Which one is it? Comparison to the COVID vaccine. Yep, this one right here. All right, let me make sure that. Okay, let me make sure I'm sharing it. Am I sharing it? Not yet. Okay, there we go. And let me make sure I got the sound on. I think I got the sound on. All right, let's fine. This is from Candace's show yesterday, where she compares Erica Kirk to the COVID vaccine. So let's go ahead and watch this.
What happened over the weekend finally put Erica Kirk within a context that I can understand. Erica Kirk is the COVID vaccine. Okay, no one can debate this. I'm right. It's a fact. She has been introduced to the public with the exact same PR scripts, the exact same emotion, with the exact same global institutional governance and backing. Erica Kirk is the COVID vaccine, and we're now on the fourth booster. So that's fourth booster is like when everybody knows that they're lying and they know that it's corrupt. And still, they're just going to keep attempting to force it upon the population, not just on the adults, but now on the kids, right? Club America is for high schoolers, and that's coming to, you're going to take her too. And just like COVID in the beginning, there was a global emergency, right? People were fearful. Charlie Kirk died and the world felt uncertain. I didn't know who to look to. We're looking for some sort of an authority. People wanted to do their part and believe that they could come together. We wanted to believe the news media that we were all in this together and experiencing this pain of losing Charlie Kirk. Suddenly a star is born. Instant stardom, a la Dr. Fauci. But this time we've got Erica Kirk being foisted upon the public. And then things got weird. And they got weird pretty quickly, right? This is like nurses are doing TikTok dances. And we don't really know why. Erica starts making the evil eyes, and we're unsure. We're all in this together, turned into Turning Point is my family. People had questions about how quickly this was being rolled out, the vaccine, Erica Kirk. Like, really? Erica Kirk is going to be appointed the CEO and chairman this soon, a couple of days after? Doesn't she need time to grieve? Shouldn't she maybe take a beat, go home, be with her kids? Right? Now, all of a sudden, they drop the influencers. Your feed is being filled with influencers, celebrities, politicians telling you to roll up your sleeves and take the Erica. Just take it. Take the Erica. You got Nicki Minaj. You got JD Vance up there lecturing you. You got President Trump. You've got Ben Shapiro, take the Erica dopes. But something in your gut is saying, this feels wrong. This feels too fast. You get a sense like they already had Erica ready somehow. Like she was already in the chamber before Charlie even passed. Right? You're starting to look at this. This picture just doesn't pass the gut check. Now the government is starting to get a little desperate. They see.
Kind of like she was a handler, kind of like she was placed there, on purpose. Absolutely.
There's this fracture in trust. They've got a lot of money behind this thing. They're bringing in large corporations now, and they're offering you Krispy Kreme donuts. You guys remember that? Krispy Kreme donuts for free if you get the vaccine. Free beer, free marijuana joints. This is all real. These headlines. Free Super Bowl.
I remember when they did this. You guys remember this when when they were like trying to bribe us? Nobody would take the COVID vaccine, so they tried to bribe us into taking it. Oh, we'll give you free money to take it. We'll give you free coffee. We'll give you free beer, this, that, and the other. Free food. I mean, it's so wild to me. And the same thing is happening here.
Tickets. White Castle's dessert on a stick. That's weird. That one's White Castle invites all to celebrate their vaccines with complimentary dessert on a stick. Is White Castle doing dessert? It's going to be free. Sam Adams is giving you free beer. NFL, everybody's getting involved now. If you accept the vaccine. Turning Point USA is now paying their chapter leaders to stay on board because everybody wants to quit. Suddenly, we're realizing that we're being targeted. And you're thinking, is this vaccine going to kill us all? Because it's safe and effective is now suddenly she's a grieving widow. We hear it over and over and over again. Everyone keeps saying it, but it doesn't ring true. And they've got the journalists, the governments, the military, the Zionists, they're all in cahoots again. And whenever this unholy alliance begins to collude to tell you that something or someone is okay, it's because that someone and something probably isn't. Okay, is that fair? I feel like that is historically accurate.
It's always the
That
exact
means that
opposite of
brave
whatever they
people
tell
step into
you.
the fold and they begin to ask the right questions. Hey, why do I feel like Erica Kirk is going to kill me every time she speaks? Why is she dressed like an assassin? What's with the glitter pants? What exactly is she doing inside of the drapery? And then when they ask those questions, the entire ecosystem comes down crashing, trying to destroy them. Because how dare you ask these sorts of questions? And then the final stage of COVID is when we begin catching our government in outright lies. That's where we are right now. We're like, hey, government, you said that if I got the vaccine, I wouldn't get COVID, but I got the vaccine and then I got COVID twice. So what's up? And then the government, they don't like when you catch them out in lies, right? So when you catch them in something that they said, they then roll out the experts, the psychologists, the psychiatrists to convince the public that even noticing the government lies and not just trusting them blindly is something that only a psychopath would do. Why would you not just trust us blindly? Only a narcissist would recognize that we, the government, are completely full of shit and making things up as we go along. Do you guys remember that? There were legitimate studies being done by psychiatrists and psychologists diagnosing people who simply said, no, thank you, you're lying regarding the vaccine. Here's an example. I'm showing you a real study. You don't remember what we lived through, guys. It was trauma. The study is entitled The Impact of the Dark Triad Personality Traits on COVID-19 Vaccination Uptake. And here we have highlighted. We add to a deeper understanding of vaccination hesitancy by identifying what drives primary vaccination and booster uptake, as well as adherence to simple preventative measures, such as physical distancing, by investigating the role of dark triad personality traits, Machiavellianism, narcissism, psychopathy. Oh, okay. Specifically, individuals scoring high in psychopathy are associated with a lower likelihood of having received primary immunization. Guys, you're a psycho. If you question us, you're just a psycho. Again, this is exactly where we are at in the Erica Kirk story. We're asking to see evidence, noticing they have told us lies, and we're now getting diagnosed.
Yeah, because you have all these Operation Mocking Pastor, where all these pastors are going out saying we're evil, we're demonic. Not even just them, but all these influencers too, that are all, you know, surrogates of the Trump administration, surrogates of Israel or whatever. They're all coming out now. Candace is evil. She's demonic. You know, I'm evil. I'm demonic because I go against Erica Kirk. She's a grieving widow. How dare you people? You know, that it's same thing. Exact same thing is happening.
And I just have to tee that up because I'm so amazed, jaw on the floor at what took place over the weekend. Okay. So to back this up, obviously, we broke the story. We've been keeping the countdown here. As soon as I realized something was not right with this video, right, Erica Kirk carefully described to Megyn Kelly, right? She sat down with Megyn Kelly, talked about how Charlie Kirk, look at the tears in her eye, through many tears. She saw this video 3 weeks before he died. Charlie Kirk was in Aspen with some donors. And he said, if anything ever happens to me, if I die in 3 weeks, make Erica, my wife, the CEO and chairman of the company.
That video is fake.
We broke the story that video is likely not authentic. People with direct knowledge tell me that, yes, certainly a question was asked, but the answer which Charlie gave was simply that he trusted his lieutenants at the company to figure things out in the event of his absence. His mind just was not there. So this would imply that Turning Point USA used AI tools to add a sentence that Charlie never said, handing the reins of his company over to his wife. That was what that would have accomplished, right? Well, the scandal is now growing because after 46 long days and long nights of us asking Turning Point USA, specifically of us asking Blakey Neff to just release the footage, very easy ask, by the way. Remember, they already released the audio. It was them. They told the story. They released the audio. No one said, hey, make that your walkout music, Erica. We want some audio of Charlie naming you the CEO. You released the audio, so it's not exactly a major ask to simply release the video component alongside with it, right? But no, 46 days, here we are. And they're feeling the pressure. So we're not going to let up on this. This is huge, right? This could be, if we are correct and this was AI and they thought through this, we could be looking at a motive. Plain and simple. We at least would understand how positively deranged his wife is, plain and simple. So what do? They instead decided the next right step was to show the footage exclusively via a private screening, a secret private screening to some journalists over at the Daily Mail. And this journalist, Charlie Spearing, look, no, not calling him out for anything. He probably just tried to verify.
And by the way, the reason they did that is because they know they could fool these people, that these people wouldn't know the correct questions to ask. They wouldn't ask for the metadata. They wouldn't ask for the original video to be able to prove whether it was real or fake, to be able to prove if it was taken at the exact time that summit, that the donor summit happened in Aspen. So yeah, that's why they went to the Daily Mail. And also they wanted to spike Candace as well. They wanted to also throw it in her face like, we'll get you, we'll stick you.
By the video, but he wrote an article. It says exclusive bombshell secret video of Charlie Kirk naming his true Turning Point successor days before the assassination. And so people thought the video must have been embedded in here. Of course, it was not. The article is behind a paywall. People were upset they paid because they thought we were going to see this video. What they actually got was essentially the claim that the scandal could now be put to rest because just trust the journalists have seen the footage. They describe how the journalists had seen the footage.
I agree.
They, go on to receive a link and onto Zoom.
They're all the problem.
Show them on a screen. Was it actually sent to them in a separate file? Did they fly out to Arizona for this screening? No, we don't get any information. Just trust the journalists. The quotations from this article are truly exceptional, okay? Because the first point they deliver, and you can kind of see this laced in between, is why does it even matter? And this isn't coming from Charlie. This is coming from, he's speaking to donors, people around Turning Point USA, the pastors that we trust the least.
And by the way, Blake Neff's argument now is, well, why does it even matter? You know, we knew that we wanted, the Turning Point knew that we wanted Erica to take the lead. So why does it even matter if there's a video or not? So they're basically, they know the video doesn't exist. So they're trying to get out of it ahead of time by saying, well, it doesn't even matter. Who cares if there's a video? It doesn't matter. No, it does matter because it shows that Erica is a psychopath, that she intentionally lied, and it's the motive that that would be the motive for her to have wanted to kill Charlie in the first place, to take over his company. It's very important. Very, very, very important.
Who are running Turning Point USA Faith. And we're like, oh my God, Charlie said it so many times. It doesn't even matter if the video exists. This is a direct quote from that article. Several Turning Point allies feel that too much attention has been focused on the video from Aspen and said it was always clear to them that Charlie had intended for Erica to lead the organization in his absence. One board member who wished to remain anonymous confirmed.
And like I said, by the way, that's basically them admitting that this line right here is basically them admitting that the video is fake, in my opinion. They're admitting that it's fake by saying, why does it matter? It doesn't matter. And also this right here, this one board member who wished to remain anonymous, confirmed to the Daily Mail that he was personally involved with personal, financial, and estate planning with the couple after they were married. Well, I don't care if he wants to remain anonymous or not. That board member is Doug DeGroot. Doug DeGroot is the one that did Charlie's personal and financial, stock trading, estate planning, all of that, because Charlie has even said that in a video previously. So I'm going to out him right now. That's Doug DeGroot. I don't know why he wants to remain anonymous, because Charlie's even publicly said that it was him. The only reason I think he would want to remain anonymous is because he knows that would imply that he's part of the cover-up. And I'm going to say that right now. I think Doug DeGroot is 100% part of the cover-up.
To the Daily Mail, but he was personally involved with the personal, financial, and estate planning with the couple after they were married. And during those discussions, they made clear that if anything should happen to Kirk, his wife would be responsible for the organization that he had founded. Quote, Erica knows more about Charlie's feelings and emotions and where he wanted to bring Turning Point than anybody else out there, the board member said. The board already knew what the plan was because they talked about it with Charlie. Everybody knew. Okay, end quote. So it was just an open secret, you guys. But for whatever reason, Charlie, who was a literal boy genius, did not think to simply put this in his corporate will. He had one. Turning Point USA, they had a corporate will.
Exactly. That's bull crap.
Is what wills are for.
If he wanted Erica to run the company, he would have put it in paper. He would have put it in writing.
Saying this over and over again, like if anything happens to me, I just want Erica to take over this place. I just want Erica to take over this place. When it came down to the paperwork, he just skipped that part. Was Erica in the corporate will? Yeah. I'm told Erica actually was named and she inherited 10 million. That may or may not be correct. I didn't get a question on Turning Point USA, but I was told this very early on from someone on the inside. So he thought about Erica when he did his will for her to get paid. Maybe it wasn't 10, who knows? I'm actually almost certain it was like 10 million, but for some reason he didn't write that he wanted her to become the CEO. That feels like a bit of a miss. I don't buy it. It's BS. Okay. Elsewhere in the article, they explain that the reporters have seen the video, so I guess it's all good. Okay, quote, video of the Aspen donor conference has never been released publicly, but the Daily Mail has been given exclusive access to screen the full video, report on its contents, and speak to individuals who were in the room in Aspen that day, as secrecy around the footage has become a major point of contention for critics of Turning Point and its new CEO, Erica Kirk. Oh, I have a question. Why can't they just release the footage? Oh, they have that in the article as well. The excuse that Turning Point provides for why they cannot release the footage themselves is because it would violate donor privacy. It reads, quote, while the public release of the video would prove Owens's suggestions of a fraud to be false, some of the organization believe good faith efforts would be rejected. And the video
Complete
would be
crock of
weaponized.
shit.
And on top of those concerns, the donor who asked the succession question does not want her question and identity revealed to the public. Sources within the
Well, the
organization
question is,
told the Daily Mail.
the question has already been revealed. We already know the question. So the only thing that she could be worried about is having her identity revealed. And like Candace is about to make the point here, that's very easily fixed by either cutting it right after she asked the question and just leaving the part where Charlie answers it, or you can keep the whole thing in and then just hide her identity by blurring her out and maybe changing her voice with AI. Very easy fix, but Turning Point is trying to create this false reason why they can't show it, which makes absolutely no sense. Just like everything they put out makes absolutely no sense. Horrible PR all the way around.
How's your fourth booster, guys? Not hitting the same, is it? When they say get the fourth booster, you're like, I don't want to, I feel like you're lying to me. So you can, apparently Turning Point USA can cut the clip for Erica to walk out to, and we don't hear the donor in it, but they can't do that. They don't know how to do that. They don't know how to cut a clip so that we can just see Charlie answering the question. We're to believe that they don't know how to edit videos at all. It's literally what Turning Point does. That's the whole point of all of his speaking events and going on campuses. You're telling me they can't just black out the face of a donor and cut out the question? This is the reason that they're not going to release it. Now they're concerned. Good faith question. I'm not asking you for good faith. I'm not the one who told you to roll out the sad story to Megyn Kelly and then to have it be her walkout music as she accepted the glory of taking his role at AmFest. That wasn't me. That's your terrible PR ideas. And you're just getting clocked on it left and right because information, people are working together, and people have come to me both within and outside of your organization. We now know that you were meeting with a Hollywood AI company. What a free market organization would be doing, meeting with a Hollywood AI posthumous company. We make videos posthumously. It kind of makes you think back, by the way. Do you remember when Erica, when she was on the Charlie Kirk radio show the first time back, and she was like, we have 10 years of footage that nobody's seen. She actually said speeches that nobody's seen. My producer pointed out how stupid that is. How could there be speeches that nobody's seen? Was Charlie just like giving speeches in the mirror at home? You have speeches that nobody, what 10 years worth of, how is that possible? Were they planning on releasing some footage that was being created by like?
That's a perfect argument because, any speech that Charlie gave, even if he himself did not record it, if there's an audience, there are people in the audience most certainly have recorded that and put it on social media. So any speech that Charlie did would already be out there in the public somewhere. So for her to say that there's speeches that nobody's ever seen makes absolutely no sense. Unless, as she's alluding to here, if they were trying to keep grifting off of Charlie's ghost by creating fake AI videos of him and trying to pass them off as real.
Like Hollywood companies that specialize in IA. Look, I'm not going to say anything bad about Charlie Spearing, the author of the piece. I'm sure he's a nice guy who is also just in no manner or way equipped to understand and assess whether or not what he is looking at is AI. Because AI can be uncanny. We all know this. You can go on the internet.
I don't know about her first child, but I do know that the boy that they had supposedly, I'm pretty certain, I can't say with 100% certainty, but I am pretty sure, I'm like 90% certain that she did not give birth to that son, that they either adopted him or they used the surrogate. Because we can prove that she faked her ultrasound photos. We can prove that. I've already released that last week on the channel. And obviously, like you said, there are no pregnancy pictures of her whatsoever, anywhere, ever. Like something like that, as much as she posts online on social media about her life and about her kids and everything, that's something that she would have posted had there been pictures.
You can see AI videos of me and people believe that they're real. I have a French channel. You guys know how bad my French is. It's terrible. Go to my French channel. It's perfect. I speak French better than a French person. And I have to
Exactly.
I can't even actually think through what they were expecting the response to this article to be. Like people were going to go, oh, okay, that's it. We trust the experts. No, as you can imagine, this appeal to non-existent journalistic authority immediately backfired badly, bigly, because like I said, the literal trust the experts narrative has collapsed. Here are just some of the tweets of people reacting to this article and this video. This person writes to responding to Blake Neff, why are you all acting like this is a sex tape or something? You released the audio. Why not the video? It's so odd. BTW, you lost the whole we don't owe you anything line when you enlisted a Daily Mail reporter to help dispel questions. You can't have it both ways. Another tweet, Erica posted a video of her kissing Charlie.
I would say that they also lost the we don't owe you argument back when they got caught openly lying and submitting fake photos as proof of their alibi. I think, you know, that showed that they're acting in bad faith to begin with. So the trust me, bro, they've lost that. There is no trust anymore. They've broken that trust agreement.
These dead hands. But this video crowning her the CEO is private? Shut up. Like, so true. Thank you, Courtney. You are correct. Last one. The reason nobody believes this video exists is because it would have been played right after Erica posting the video of her hanging over Charlie's dead body. Again, you guys don't get to play private now. I mean, you guys were just ringing Charlie for every single red cent you could have. We had tents up. He died under that tent. You want a selfie? That'll be $5, please. Thank you. Freedom shirts. He died in that shirt. Would you like a Freedom t-shirt? That'll be $50, please. Thank you. Merch, hats, sales, numbers. Now all of a sudden it's, well, this is private. We introduced it, but this is private. And so what happens now? Well, every time you just get caught in a lie, diagnose away, right? I called out Blake Neff. He writes this long tweet thinking that this was the booyah boy Blake over here. I like that. Booyah Blake. And it's never a booyah. It's never, ever a booyah when it comes to Blake. It's just, you're going to get booed, Blake. And he was like,
Blake Neff and Andrew Colvett, my nickname for them, which I think is spot on, is Tweedledee and Tweedledum. I would say that Blake would be the Tweedledee and Andrew would be the Tweedledum.
oh, let me recap everything that happened with the Daily Mail reporter. He wrote this. Of course, no, the video is actually.
Oh, by the way, they have already responded and talked about the case on their live stream, once again, prejudicing Tyler Robinson already. So we're going to show that next. Once she's done this, then we're going to go to that and we're going to react to that. I haven't seen it yet, but I just saw that they posted something reacting to it. So now we're going to react.
Needed to prove Charlie wanted Erica to succeed him. Everyone who knew Charlie well and spent time around him knew this was the case. So the fact that he's just going to go ahead and say, no, the video is not even needed is, again, they're just now gaslighting us, right? And then he says, Candace is now screaming that the video must be made using AI, exactly as I said she would. Candace has publicly accused the Mail of lying about contacting her. So he posted a screen grab. That was actually a mix-up. My PR just never forwarded the email. And like I said, I'm happy to have a conversation with the Daily Mail reporter. But again, he's always looking for a booyah. There's not one. Instead, what he got was an absolute ratio. People calling him out, as I just showed you some of these tweets, being like, no one believes you, Blake. This is ridiculous. This is.
Yes. Andrew Colvett, I can't prove for sure whether he knew Erica before, but we can definitely tell that Andrew Colvett was intentionally set up. What happened was there was a person that worked for Charlie early on that made some racist comments or whatever, and it was a huge firestorm all over the media. And he was in a crisis and he needed somebody, he had to deal with the PR. So he needed somebody to handle the crisis PR. And we can prove that I'm pretty sure, my belief is that event is staged. I believe that they intentionally did that because we can connect that woman back to the very first donor that Charlie had ever. And so I think she was introduced into the company on purpose. And I think she made those statements on purpose. And I think that they intentionally created that scenario, that media shitstorm, and then introduced Andrew, because Andrew kept trying to get in with Charlie, and Charlie's like, nah, he kept ghosting him until that firestorm, that media firestorm happened, and then he finally said, okay, I need your help. I'll let you give it a go. But I think that they intentionally, just like everybody around Charlie was a handler, they were all put in place to handle him, to guide him, to push him in the direction they wanted him to go. And Andrew Colvett was one of them, 100%.
Absolutely ridiculous. And I said, the ratio here is exceptional. Like, pay attention to what people are saying. The people have spoken, Blake, and they are not on your side. Release the video.
Big time.
and let
Boyer,
us be
big
the
time.
judge of who's right
Absolutely.
About what.
Tyler Boyer, we can prove that we can definitely prove that she knew we can definitely prove that she knew Tyler Boyer way before she married Charlie, way before she first, supposedly fell in love with Charlie at the Bob's Burgers or whatever, because they went to Arizona State University together. So we got them linked all the way back to Arizona State University when they knew each other, at a very minimum, if not even longer than that. We think it goes back even further, back to Romania. But she's even on video. She's even caught on video saying that Tyler Boyer, lying, by the way, because she's said that she didn't meet Tyler until the 2015 Trump rally or whatever, which that's a complete lie, because she would have had to have known him to get invited to it, first of all. But secondly, in another interview she slipped up and said that Tyler Boyer is a family friend. So they clearly knew each other well before Charlie. So Tyler was put into Charlie as a handler. Andrew Colvett was put into Charlie as a handler. And the two of them together colluded to set Erica up with Charlie as a handler.
And Blake said, yeah, Candace, since I'm not a malignant narcissist, I don't actually care what my ratio is as long as I'm speaking the truth rather than lies. But just to play along, quote, wide is the gate and broad is the road that leads to destruction, and many enter through it. But small is the gate and narrow is the road that leads to life, and only a few find it. Well, Blake, I'm not sure which road you think you're on, buddy, but you might want to pull over and get some directions. Okay. I'm going to leave it at that. What should our takeaway be here? Boys and girls, our takeaway should be Hunter Biden was smoking crack, but what's Blake's enough excuse, right? What is Blake's excuse? What is Andrew Colbett's excuse? What is Erica Kirk's excuse for this buffoonery? Because that's what it is. It is buffoonery. How much longer can this go on before they stop, right? For COVID, it took years before they finally admitted that the vaccines were not safe and effective. Is it going to be years before they acknowledge that the Grieving Widow Act has failed terribly?
Yeah. So, like I said, that was perfect. That comparison that Candace made between Erica Kirk, comparing her to the COVID vaccine, spot on. Honestly, that masterclass, perfect, 100%. Yeah, absolutely. She 100%. I think Erica is definitely demonic, big time. So anyway, like I said, let me go ahead. I'm gonna make this as a standalone video, so you guys are gonna have to bear with me here. So just let me do a little intro real quick. Hey guys, it's me, Colin, Project Constitution. looks like Andrew Colvett and Blake Neff have already responded to the Tyler Robinson hearing today and are once again making remarks prejudicing Tyler. So let's get into it. All right, hold on, guys. Let me. Okay, let's do this one. All right, so yeah, we're going to react to this. This is from the Charlie Kirk show today, where Andrew Colvett and Blake Neff have already parroting the prosecution's talking points that they just made in this case, prejudicing Tyler Robinson yet again. And like I said, Blake Neff is under a gag order. He's a witness in this case. He's not allowed to talk whatsoever. Blake Neff, like I said, so Blake Neff, like I said, is a witness in this case. He is not allowed to talk about the case whatsoever. He's not allowed to go out there and make remarks on it, extrajudicial remarks while the trial is taking place that prejudice Tyler Robinson. And that's exactly what he's doing here in this clip.
It seems to be most of this around so far has been around as they're trying to get one of the prosecutors held in contempt for breaking a gag order, and it appears to be related to that ATF report, which was the first time we had you on the show. What are you hearing and seeing, Jay?
Yeah, so Rule 3.6 of the Rules of Professional Responsibility, which every lawyer has to follow, and as a prosecutor, relevant here, says that it involves pretrial publicity. And so you can't make extrajudicial statements, meaning out-of-court statements, that would materially prejudice the defendant. So let's say I know something is hearsay and inadmissible, but I go on TV and I talk about that evidence, knowing that a jury's never going to hear it. That is an extrajudicial statement that does materially prejudice a defendant and is prohibited. The problem, and I'm glad the state prosecutors nailed Robinson's defense counsel on this today, because this bugged me the first time you had me on your show. And all we didn't have the ATF report at the time.
What did they nail? They didn't nail anything. The prosecutor was stuck with his tail between his legs, basically admitted that he made a mistake, and he said he won't do it again, is basically what he said. He tried to blame the defense and say the defense, made misleading statements in their motion, but that's not true. The defense called him out and said, hey, that's not true. We didn't say anything. We didn't say that, it did this. So he's completely lying here.
But I told you that I guarantee you that ATF report suggests that it could not be excluded that the bullet found in Charlie Kirk's body came from that rifle. It wasn't just that they were unable to identify a match between the bullet and the rifle, and that it was a .30 caliber class bullet, meaning that's the type of bullet that is fired from the gun that has Robinson's DNA on it. But that.
And you know how many other guns are .30 caliber? A huge percentage. It's only like a 6% chance that it was even from the same type of rifle that Tyler Robinson allegedly had. So they did not make any statements at all that were misleading. Okay, this is this guy he's sweeping for him, obviously.
Was excluded from the defense counsel's motion. Sure enough, we get the ATF report. It's exactly what it said. We also.
And once again, like I said, the defense did not make any misleading statements. The media themselves went out and ran with it, saying that it excluded it as evidence. And honestly, I don't see that as misleading. It does exclude it as evidence, in my opinion, because it cannot conclusively match to the rifle. So therefore, it cannot come into trial. So therefore, it's exclusionary, right?
Understand that it says it's unable to identify or exclude right? Or exclude, meaning we don't know because it was such a badly damaged, shrapnel mushroomed round that was found in Charlie's body.
Or here's a thought, it wasn't a round at all. It was a chunk of metal from the microphone receiver that was on his waist. How about that? I don't think it was even a bullet whatsoever.
So we just can't give any meaningful analysis to it to match the striations of the 30-06 that was found.
And Jay, just don't mean to interrupt you, but I got to throw this original image up. So this all came back down to the Daily Mail article that came out at the time, which let's just read their headline here. Bullet used to kill Charlie Kirk did not, all caps,
did not match.
Match rifle allegedly used by suspect Tyler Robinson, new court filing claim.
And it didn't match.
This sent the internet and the Twitter sphere absolutely bonkers, ablaze, crazy, right? So
number one, it didn't match. Number two, that's not what the defense said. That's how the media interpreted what the defense said. So the prosecutor is not allowed to go out there and correct stuff that the media gets wrong. They can only correct stuff that if the defense says stuff, does things wrong in their motion. If the defense makes a motion, if the defense in their motion says something that is misleading, then the prosecution would be allowed under that rule to make not a statement of guilt or innocence, but they would be allowed to correct the record and say, this statement is not true. What it actually says is this. And that's obviously not what happened, because the defense did not make any misleading statements in that motion. The media took what the defense said and interpreted it to mean something else than what the defense said. And the prosecutor reacted to the media, not what the defense did. And he went out there on Fox News and sent a whole bunch of emails to all these other media outlets like Andrew Colbert and TMZ and Fox News and all them, colluding with them to tell them, hey, these are the talking points you need to say. That is not what a prosecutor is supposed to do. That violates the rule. And therefore, it's a proper motion that they filed to hold you in contempt.
For it was 36 hours. This thing did, I don't know, 40 million engagements on Twitter alone, let alone all the YouTube videos that were made of it, TikToks and everything. So this misleading headline went probably 3 times around the world before the truth had a chance to get its pants on. And so the defense attorney or the prosecutors apparently, let me just pull up the exact quote. Because it is important. I want to make sure I get my exact quote here, sir. He apparently spoke to the press, and this would be Chris Ballard on the prosecution's team, said when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and then we will present all of that evidence at the trial. When you hear that quote directly, so this is the quote in question that they're saying that that Chris Ballard should be held in contempt for making that statement to the press. When you see it in context, right, of what the media was doing, the Daily Mail article specifically, that you came on the show the next day to.
Once again, it's not in context of what the media does. The prosecutor is only allowed to respond in context to what the defense does. They're not allowed to react to the media. That's the problem. They're completely glazing over the problem, which is they reacted to something the media said, and then they went out there and made extrajudicial statements that prejudiced Tyler Robinson.
Rebut. What do you feel like he broke that rule, or do you think he's well within his rights?
No, absolutely not. And here's why. The defense motion that said that they were unable to identify that bullet matching the gun, and that they want to call the ATF now to present exculpatory, meaning not guilty, didn't do it. You can't prove this beyond a reasonable doubt because there is exculpatory evidence in this ATF report. That's what the defense motion said. Like you said, That went around the world before the truth could put on its pants. And so under Rule 3.
No, the gun cannot fire. I'll get into that after we're done reacting to this.
0.6 that was heavily cited by defense counsel today. It allows the prosecution to go out and correct the record when they have been materially prejudiced by incorrect and misleading statements. And he nailed the defense counsel. He didn't say that it was their intent, and he didn't blame the media for running with it. Who wouldn't, right? If you read that motion, you think, oh my God, the bullet doesn't match the gun. I knew what it meant because I've read hundreds of firearms and tool mark reports from the ATF. And the defense counsel knew what it meant too. Being too smart by half, and they were called on it today. I don't think that the judge is going to fall for this. This is absurd to me. Maybe he'll entertain some more motions, but there is nothing contemptuous about correcting the record when they've been materially prejudiced, they being the state of Utah.
Yeah, so clearly that guy is just sweeping for Colvet and for Turning Point. The guy's full of shit. His argument is garbage. I just laid out why. Don't listen to anything these guys say because they're obviously all lying. They've been caught in lies time and time again. Once again, they're prejudicing the jury to contaminate what they're prejudicing. I'm sorry, they're prejudicing once again. They're prejudicing Tyler Robinson and contaminating the jury pool, tainting the jury pool. That's what they're doing. Don't fall for it. And the judge, we'll see on June 1st when he makes his ruling, but I'm pretty sure the judge is going to rule in favor of the defense to have an evidentiary hearing on this, where they will get a lot more proof that just shows exactly how much they've been colluding with the media, which is way more, in my opinion. I think they've been colluding with the media way more than what they want you to believe. So to answer your question about the gun that cannot fire while we are at it. So this right here, this is a post that I put out. When did I put this out? I put this out April 21st is when I put this out. But the fatal flaw in the Tyler Robinson case, gun could not have been fired. And the rifle the feds are trying to sell you as the murder weapon is not the actual gun recovered. But and by the way, yeah. So the picture of the gun that they showed us in the first place, right? Which is hold on. Let me see if I can find the picture. Right here. Okay, yeah. All right, so that picture right there. Oop, damn it. Hold on. I thought I paused it. Okay. So this picture right here.
Got
this is
my favorite.
Ah, damn it. Why does it keep doing that? So this picture right here, this is the picture of the gun that they released in the media. And they claimed all over the media that this was the murder weapon. This was the gun that Tyler Robinson used to kill Charlie Kirk. And that's a lie. This gun is not that gun. It's not even the same type of gun. Not even the same type of gun. Which also, like I said earlier in the stream, the fact that they say that Tyler's dad recognized the picture of the gun, and that's why he was suspicious of Tyler and turned him in, that's a lie, because he could not recognize a picture of this gun, which is not even the same gun that Tyler Robinson used. Now look at the picture of this gun right here. Does that look anything like this gun right here? Does that look like the same gun? No, it doesn't, because it's not. That's a completely different gun. Now, as far as why it won't fire now. Oh, by the way, so just so you know where that picture that they're claiming was Tyler's gun originally. That photo is actually a generic stock photo, and it's of a Remington 700 or a Mauser 125th anniversary model that they've edited out the background. So it's not the Mauser 98 that Tyler allegedly used. And by the way, they claim, and the reason why it cannot fire is they claim that the rifle recovered from the scene that they claim is Tyler Robinson, which is a Mauser 98, they claim that it features a $2,000 low-mounted scope, and they say that right in the probable cause statement. Now, the Mauser 98, if it has the original safety on it, has what they call a wing safety or a flag safety on the back of the bolt. So it has to flip up 180 degrees over top of the bolt in order to turn the safety off. And if you have the scope, the low mount scope on there, what it does is it would collide with the scope. It would not allow the safety to turn that 180 degrees, which would mean the gun is inoperable. It cannot fire. It's a prop. And that's also why I think that the FBI and the ATF are refusing to allow Tyler Robinson's defense team to examine the rifle, to take pictures of it, to see this rifle in person. They have still yet to been able to see this rifle whatsoever, because if, like I said, I think it has this original safety, and if it has this original safety, then that would mean that it's inoperable and it's just a prop and did not fire. It could not have fired. And I'll show you the video I put together, which proves it here as well.
Mauser 98, not necessarily this specific one, but somebody's got one of my favorite type of guns, Mauser 98, not necessarily this specific one, but somebody's done a sporter job on her, and the gun's in the shop for a low scope safety. So they've mounted a scope, they got a low bolt handle, all well and good, but they got the military safety, which isn't conducive to our scope, obviously.
It would have to rotate 180 degrees past the scope in order to turn off the safety. And it's impossible to do that if it has the original safety. Now, they do make aftermarket safeties, which you can replace the original safety that came on the rifle with a low mount or side mount safety, which would fix that problem to where it would be able to engage the safety. We don't know for sure whether the rifle has that or not. So like I said, that's why they're not showing the pictures of it, I think, is because if this rifle has that safety, then it would prove that the gun could not have been fired. Here, complete forensics on the Charlie Kirk shooting. Okay. Yeah, we can take a look at that real quick, I guess. Independent forensic analysis, pixel flow mapping, obstacle, acoustical source separation, gas release imaging. The evidence tells a different story. September 10th, during a public event at Utah Valley. On September 10th, 2025, the evidence tells a different story. On September 10th, 2025, during a public event at Utah Valley University, a young man's life was forever altered. Tyler Robinson now faces the death penalty, but a meticulous frame-by-frame forensic analysis of multiple eyewitness video recordings reveals physical evidence that demands closer examination. The independent investigation applies computatorial pixel flow analysis, dense optical flow mapping, multi-angle stereo acoustic analysis, audio visual source distance computation, gas release imaging, and physical evidence examination to reconstruct what the video evidence actually shows. Computed from the necklace kinetics component, velocities and shirt deformation work exceeds a single LiPro thermal runaway, suggesting a triggered cascade. Dense optical flow identifies the peak motion epicenter at the precise location where the Rode Wireless Pro transmitter was clipped to the victim's shirt. And I actually disagree with that. I think it was actually it wasn't the actual microphone. It was the transmitter on the belt. He had the Rode Wireless 2 receiver, which was on his belt. That is what I believe shot the shape charge out of it into Charlie's neck. Frame by frame analysis of video. First observable shirt movement at frame 68, first visible blood at frame 81-82. 30 times to 110 times longer than Bernoulli Torricelli physics predicts for an exposed vascular neck wound. Gas motion video shows gas escaping the collar 1 frame before the mechanical displacement. Gas first, mechanic second is a hallmark of an internal energetic event. This critical event unfolds across a handful of video frames at 30 frames per second. Each frame captures 33.3 milliseconds. Within the window, a cascade of physical events occur in a forensically significant temporal order. So you have gas release, faint gas visible escaping from the front shirt collar, no mechanical deformation yet. This indicates pressurization from a gas-generated event beneath the shirt, consistent with lipothermal runaway products. Absolutely. I 100% agree with that. Explosive shirt deformation. Dramatic rapid deformation. Back right collar expands, correct. Front panel inflates, yes. Metal necklace snaps and launches upwards at 21 plus milliseconds, 47 miles per hour, requiring 6.8 joules of kinetic energy. I agree. Component ejection. The Rode circuit board traverses the shirt interior at high velocity, pulling the collar up. Battery follows towards the neck. Magnetic clasp lags behind on the same trajectory. This is where I disagree slightly. I think whatever was shot up from the transceiver, which is directly, or the receiver on his belt, which was directly in line with the injury to his neck. And you can also see, by the way, in the pictures that I've showed, you can see that there is a massive burn or bruise where that was from it rubbing from the pressure. Once that shape charge went off, you could see that it definitely, like I don't know if it's a rug burn or what, but from the thing being pushed against his stomach, it left a very, very bad mark. And you could see that under his shirt even before as well. Bleeding onset. Flame 68 marks the first observable shirt movement. And that's another thing, is the shirt started moving before there was even a wound in the neck. So that tells you right there that whatever was happening happened under the shirt, and it was not caused by a bullet to the neck. So frame 68 marks first observable shirt movement. First visible blood appears at frame 81 to frame 82. 13 to 14 frame interval at 30 frames per second. Bernoulli, Torricelli flow from a carotid or jugular wound predicts visible blood within 4 to 14 milliseconds. The observed delay is 30 times to 110 times longer. Decorticate posturing appears within frames of initial deformation, 0 to 4 seconds before the neck wound. This sequence suggests brain injury preceded neck trauma. Absolutely. And we're not going to get into all the pictures and stuff, but you go check this out. This is definitely a good website here to check out. Another one that you guys could check out, which is another good website, is whokilledck.com. This is another good website. This has a very good, you can go through the analysis here. It says exploding mic theory, where it kind of gives you a little bit of hypothesis on it, some evidence. That was such a weird picture. I mean, like this picture alone with Erica standing over the casket, crying over it, like that was so freaky, man. That was one of the first red flags with me for Erica, which was like, nah, there's something not right about this chick. But anyway, she can go through all of that. The little black specks from the microphone shattered the glass on the floor, the cardboard or the floorboard from Accurate Energetic Systems. The timeline on this is really important, though. If you go through, they've got a timeline thing here, and you can go through the timeline and you can just see everything. You can see, you know, all these people were searched from Google Trends before Charlie Kirk was killed. I mean, you have as early back as 23. Lance Twiggs was searched from DC in 2023, 2 to 3 years before the assassination. Thomas Crooks was searched from Israel 6 months before the Butler assassination attempt. And then you got the messages to Charlie Kirk. Kirk claims U.S. intelligence agencies run the country in an interview. Turning Point cancels the bulletproof vest contract for Kirk in spring of 25. April 6 of 2026, Losey Center search from Huntsville, Alabama in spring of 2025. Mauser 98, the alleged rifle used to assassinate Charlie Kirk, searched from DC on, I can't read that, but August 27th, 2025. Oh, April 20th and August 27th. Tyler Robinson's defense attorney, Catherine Nestor, searched from an Israeli IP address. Somebody in Israel searched for her on December 21st, 2025. That's very telling. It tells you that the defense is working against Tyler Robinson, as well as the fact that Michael Burt, who's one of his defense attorneys, is the cousin of Terrell Farnsworth. Yeah, that's also a massive conflict of interest. And our buddy Paramount Tactical, the retard Gary, he also was searched from DC on April 22nd, 2025, prior to Charlie Kirk. And then Accurate Energetic Systems got the award for the explosive charge to make the explosive charge that they used to kill Charlie. That was on May 1st. So we won't go through all of it, but I highly suggest that you check this site out as well, because it has a very, complete timeline here. And you could see everything. I mean, like they searched Timpanogos Regional Hospital. They searched all the doctors like Stephen Nealman, Lee Patterson, Trotter. They searched them all from Israel. Mikey McCoy searched from Israel. The Patsy searched from Israel. Where the gun was found, 683 West 95th Street, was searched from DC. I mean, that should tell you alone that there is, collusion. There's definitely a plan, conspiracy to kill Charlie Kirk. There's no other way to look at this evidence. And, FBI, once again, Kash Patel guts and fires the entire Utah FBI leadership. That was done on August of 2025. Schaefer Security and Hunter Kozak searched from Israel August 2nd. And the Hamptons meeting happened August 4th. August 5th, Kirk rejects Netanyahu's funding offer to take Turning Point to the next level. Kirk outraged in an interview with Megyn Kelly about pro-Israel pressure on the 6th. Plane tail number N1098L and former, I don't know what that is, search from Israel. I'm not sure what plane that is off the top of my head. I don't remember the tail numbers, but that's one of them. And then, of course, August 13th, Harrison Smith posted that Kirk, he posted about Kirk featuring Israel, said that Israel would kill him. Charlie Kirk told Harrison Smith that he felt that Israel was going to kill him. So that is the they. So Charlie, from as early as August 13th, was telling people privately and publicly that he thought that Israel was the they that were going to kill him. How is that not a motive, by the way? How are they not looking into foreign involvement? How is Kash Patel shutting down foreign involvement when you have that? When you have all these Jewish donors pulling out their money? When you have them making threats to one Jewish donor that made threats to Charlie, I think it's like 2 days prior to him getting killed. It's just wild to me. Anyway, so we're not going to go through it all, but yeah, check out this site. Very good site. A lot of information here. So that's a good site as well. Again, it's whokilledck.com. All right, guys. So, well, let me check to see if there's any super chats, real quick before we go. Nope, no super chats. I did get a Cash App. I'm not going to say your name because I don't know whether you want me to or not, but thank you for the person that sent me $8.88 Cash App. Thank you for your support. Love you guys so much. Like I said, I'm not monetized, so any support that you guys can help out would be appreciated, especially because they are really targeting my channel hard with the shadow banning, trying to, basically bankrupt me to get me to shut up, which I will not. I refuse to shut up. But yeah, so we can't do it without your guys' help. So if you want to help out, you can donate at the link, which is pinned in the chat right there. And it's, like I said, it's also pinned in the chat. So with that being said, we will call it a day for the stream. That was the hearing. That's what we got for you today. Thanks for joining us, and I will see you guys on the next one. Love you all.